seminar about intellectual property in Europe, same rules, different practice or not. So we will see this morning 3 very relevant roundtables, and we will start with our first roundtable, moderator or chair by Caroline Leukovic, professor of the University of Lille. And also good morning, I would like to say good morning to our students from the Magister Lucentinus here in the room, and also the students from Lille online. So thank you so much, and Caroline, you have the floor.
Thank you very much, Pilar. Good morning, everyone, and thank you. I really want to thank my co-organizers, and especially my good friend, Professor Pilar Montero, because I know how much time and energy and effort she put into this event. And you did wonderful, Pilar. You achieved, wonderful organization with fabulous speakers. So thank you very much. And this morning we're going to talk about convergence vectors. So just to explain, yesterday we talked about convergence factors, so the driving forces for harmonization, and we discussed how external concerns such as competition requirements and also environmental concerns actually impacted the harmonization of IP in Europe. Today we're going to talk about how this harmonization is carried out, and we're going to start by focusing on 2 issues. We're going to discuss how this approximation of laws is achieved, and we're going to have 2 approaches. So first we'll discuss the top-down convergence. This is going to be our roundtable, and after the break we'll talk about bottom-up convergence. So about top-down convergence, we're going to identify 2 factors for this approximation. First, we're going to talk about the influence of the Court of Justice of the European Union. I see it just popped up. And we'll discuss the notion of autonomous notions or concepts. We were discussing with my neighbor Ignacio which words are actually used by the Court of Justice. Ignacio had an interesting remark. He said that we find both autonomous notions and autonomous concepts. I think mostly concepts, but in French we say notion, and in Spanish noción. So this is going to be the first topic, and to address that, I have the pleasure of introducing 2 speakers, Stéphanie Carr, who is an associate professor at CEPI in Strasbourg, and Ignacio Rabasa, who's a professor here at Alicante, and he's the coordinator of the copyright module in the master. Thank you very much for being with us. And after that, we'll have another session, which is completely unrelated, so I'm not trying to pretend there's a link, but we're going to discuss something very current, which is European patents with unitary effect and the UPC, the Unified Patent Court. As you know, the system just came into force this summer. And to address that, I have the pleasure of welcoming Alberto Casado, who's a collaborator at BILOS, and he's the former vice president of the EPO, the former vice president of OHIM, and also former director general of the Spanish Patent and Trademark Office. Thank you very much, Alberto. And Alberto will be joined by Emmanuel Gouget. You're welcome to come. So, Emmanuel is a partner at Pinsent Masons in Paris. So to begin with, let's discuss the Court of Justice and the importance of autonomous concepts. So let's begin with a definition of autonomous concepts. What is an autonomous concept, Stéphanie?
Thank you, Caroline. Ladies and gentlemen, here and away online in Lille, dear colleagues, dear friends, let me first thank the organizer for the kind invitation and the confidence they put in me. I'm very happy to be here and to share some key points about a very important and very interesting, that is my opinion, and I love it. I will deal with it through 5 questions. What? Why? Since when? So what? I may miss one. First, what is an autonomous EU concept? And maybe we can see the slide. Yes. It is a concept or a notion in EU legislation, either primary or secondary one, like in directive or regulation. It is a concept in EU legislation with no express references to the law of the member state for the purpose of determining their meaning and scope, and for which a European definition is given, sometimes in the EU provisions themselves, but more often by the ECG. So why this definition by the Court of Justice? Because for the Court there is a need for uniform application of EU law, and the principle of equality require an autonomous and uniform interpretation throughout the European Union in order to achieve their objectives, the objective of the treaty and of the acts in which these notions are integrated. And the court find her responsible for it. Indeed, the Court of Justice is one of the EU institutions which shall notably advance the objectives of the treaty and ensure the consistency, effectiveness, and continuity of its policies and actions. And the role of the Court of Justice under Article 19 of the Treaty on the European Union is to ensure that in the interpretation, but also in the application of the treaties, the law is observed. So its role goes beyond that of a jurisdiction, a normal one, if I may say. Very, very important principles have been built up by the court. The principle of supremacy of EU law, the direct applicability of it, and you may know those very, very important cases, Van Gendenlos and Costa. Obviously, the court competence goes beyond that of a single judge, if I may say so. The court is the judge to decide on the fulfillment of the member states' obligation under EU law. She is deciding on whether a EU legal text is valid or not. She may decide the fulfillment or not of the objectives of the treaty. And the court may decide that EU institutions have failed to act. And this is, of course, also to the court to tell what is the interpretation of EU law with preliminary rulings. And obviously it is through that proceedings that the court is identifying and defining autonomous EU concept. Since when the court is using this very useful tool that is autonomous EU concepts or notion? In copyright, this is since the Senate case and the Sky case, you may know that last one, because it was about a Spanish hotel. What we can note is that with InfoPac case in 2009, there is an exponential development of the autonomous notions of European Union law. And some academics say that there is no such an interventionist or bold, active jurisprudence of the court in other area of private law. Indeed, since the adoption of the InfoSoc directives in 2001, the court's case law in copyright is mainly grounded, based on the determination of those EU autonomous concepts. So how the court is defining an autonomous EU concept? Its methodology is characterized by a theological and systemic approach. And I call it, because I love the word, teleosystemic approach. That means that the court is interpreting EU provisions, of course, starting from the letter, the wording of the legislation, but above all, with regards to its purposes. That means the purpose of the EU provision itself, but also taking into account the purpose of the body of rules in which it is fitting, and the purpose of the directive or the regulation by itself. Therefore, the court paid great attention to the recitals. The court also characterized the method to interpret and define autonomous notion with regard to the necessary imperative coherence of EU law. And finally, the court is defining those notions with regard to the imperative of a useful effect of EU provision. Within this framework, the court may call on, for example, the will of the legislator. And in its reasoning, sometimes it is calling on the travaux préparatoires or the recitals. And the court often also call on the Convention of Berne or the WIPO treaties. But I have to say that with those texts, the courts do what you want. So what? This very bold, activist, creative interpretation of EU copyright law is really like a path to complete the harmonization made by the legislator. It is a kind of bold lawmaking. And in a way, to me, it is a way to unify EU copyright law. And a very useful example of this is the notion of originality and protected works. Dear colleagues, I made the... Huh?
Perfect.
Thanks a lot of for this presentation. Of course, thank a lot of all the organization and the assistants too. I'm going to talk about the autonomous notion of the autonomous concept of work in the European Union. So, okay. It's okay? Okay.
Yes.
Okay. Excuse me. Okay. I'm going to talk about the autonomous notion of work or autonomous concept of work in the European Union. But I don't like it doesn't. Okay? Why not?
Do you want me to do it?
I can I
Yes.
Okay, thank you.
It is because you are sleeping, so we move.
again, the concept of autonomous work, of autonomous notion, is the basis of copyright under European laws. As an introduction, in its conception, intellectual property has been a discipline linked to the market. In the context of single market in the European Union, the harmonization of IP law between different member states has been sought. This harmonization has been achieved not only with a progressive implementation of regulation and directives, but also through the implementation of an autonomous concept developed by the Court of Justice. In the following presentation, I will briefly explain the autonomous notion of original work. What's the problem? Interestingly, the legal framework of copyright, which in practice confers on its beneficiaries stronger rights, or maybe not stronger, but at least longer in time than other IP rights, such as patents or utility models related to technical creations, is sometimes characterized by the difficult delimitation of the protected subject matter. In the case of work in copyright terms, it's more rigid, more abstract. Except for some specific categories, as software, photographs, and databases, there are no legal text in EU law where a concept of protected work is expressly and univocally defined. The same is true of many national legal texts, which do not provide an abstract definition of the concept of work, but rather a non-exclusive list of types of protectable works. This is the case as an example of Spain or Poland core laws. What's the justification of an autonomous concept or notion in the context of copyright? For me, the best sentence is the general advocate in the case of COFEMEL. The concept of work is the cornerstone of any copyright regime, insofar as it defines the substantive scope. A uniform interpretation of that concept is therefore necessary in the harmonization of the copyright established by European Union law. Okay, we can do new directives, new rules, but if we have not a common concept of the basis of the nuclear element, the work protected as copyright, these directives don't let their objective, because there's not a basic notion of work. Fortunately, there's a lot of sentence of Court of Justice that delimitate the concept of work. Taking as reference the Berne Convention, TRIPS, and national case law of some European Union member states, as an example, Spain, Poland, Germany, France, the Court of Justice has built an autonomous concept of work based on two cumulative requirements: originality and expression. The most difficult, or usually generates some problems, is the originality. What is originality? According to Pioneer or COFEMEL, if a subject matter is to be classified as work within the meaning of copyright, it must be original in the sense that it is author-owned intellectual property's creation. So what is an own intellectual property creation? A work is author-owned intellectual creation, if it reflects the author's personality. Okay, it seems a slightly, at least, tautologic definition. We need to do another question. How can we know if a work reflects the author's personality, and consequently, if it is original? First of all, a trick. It's easier to formulate the question in a negative way. When does a work not reflect the personality of the author? In this context, the Court of Justice is more clear. If the work and the outcomes are dictated only by the technical result. In this context, it not be protected as copyright, because the author has not freedom to develop a work in an autonomous way. Also, if the work constitution is dictated by rules or requirements that leave no room for creative freedom. There are famous cases, the case of football calendar in Football Dataco. A football calendar can be protected as copyright sporting events, particularly football match, can be protected as copyright, because maybe there, in football matches could be space for creativity, but not originality in the sense of copyright autonomous notion, because the movements, the strategies of football players depends of the other players. Okay, it happens the same with other sportive events, or maybe other spectacles. As an example, in Spain, bullfights can be protected as copyright because the actuation of bullfighter depends of the bull, of the bravery of the bull. The same happens with chess. A chess match depends of the movement of one player, depends of the movement of the other players. However, in this case, it is possible that 3, 4, or even 2 expert chess players write a book with a chess movements created by them. In this case, this book will be original, because in the context of the books, they are not limited by a concrete match. In this case, it will be protected, but not the match per se will be protected. Notwithstanding the above, the fact of having a creative freedom in the execution of a work does not automatically imply the result of it's an original work. Okay, the most clear case is the photographies. We can protect the photographies as an art with originality standards, or we can protect the common photographies with less rights. In order to be works under copyright parameters, it is mandatory outdoors creation reflect her or his personality. We return to the same problem. Again, when a work reflects the author's personality. Another trick, we must to focus in the link between the author and the work. It is important. The link with the author, not the link with the work with third parties. It's the link between the work and the author. Okay? By contrast, a priori, it is not enough to analyze the characteristics of the work in isolation from this author. An example is the co-female case, the circumstance that a design might generate an aesthetic effect in third parties does not in itself make it possible to determine originality. In the co-female case, it's a case about trousers, jeans, who generate a singular effect by consumers. But it is not enough, because the relation of the work might be linked with the author, not with others, third-party, consumers, customers. Okay. The originality criterion should not be fully replaced, but others that are not legally equivalent. These concepts could be useful in order to determine that exists originality, but can be substitutive of the own originality autonomous notions. Originality in this case is not the equivalent to novelty. As you know, novelty is used in patents, utility models, designs, and the difference between originality and novelty is next. If we have originality in an originality context, both authors can take a photo in the same landscape at the same time, but both of them can protect their work if both photographs have originality. However, in novelty parameters, only one invention, only one design can be novel strictly according to law parameters. Another concept that we must take into account is the effort and skill. Effort and skill is useful in order to determine if exists originality, but it is not enough. Effort and skill predictable qualities of another creative, but they are not sufficient by themselves to consider that there is a work susceptible to protection. There's a case about a military calendar, very, very detailed. In this case, there exists effort, exist skills in order to do this a calendar in a precise way, but there's no originality because it's not the expression of the author. In order to finish, the second requirement about the first is originality, the second is expression. According to expression, is a requirement based on the old axiom that copyright does not protect ideas, but the expression of these ideas would be protected. According to Court of Justice resolution, classification as works is reserved to the elements that are the expression of such creation, as an example in InfoPack and Lebola and Hello cases. The requirement of expression serves the function of providing legal certainty insofar as it prevents the protection of words that cannot be expressed, identified, delimited in a precise and objective manner. This is the case of Lebola Angelo, when a company tried to protect the smell of a cheese by copyright. The Court of Justice denied the protection because consider, in this case, that the smell can be fixed, can be identified in an objective way. We have not the tools to concrete, delimitate a particular smell. So in this case, it can be protected by copyright. So thanks a lot. Now continue my workmate, Professor Carr.
Thank you very much, Ignacio. So Stephanie will present notions about communication to the public, briefly.
Okay, that's fine because I've been asked to speak about another example, but in 5 minutes. So that would be a challenge because I've been also asked to speak about one of the most difficult jurisprudence to resume in 5 minutes. There's a lot, and I will take the communication to the public as an example. As you may see, I will not speak about all those case law, even though they are very important, but you will have all the references, and that's good. And it is not exhaustive. What is worth to note about this step-by-step case law is that the court is linking some judgments to others and not to all of them. That means that for the court, it is a useful tool, is using what we call block of jurisprudence. So that may be a key point when you will read all the case law. And we have to bear in mind that the judges of the court are not IPR specialists. So they are learning by doing. And this is important because we cannot, for example, scotch to a wording because maybe they are not aware of what the meaning about this term. The decisions are highly pragmatical, and the reasoning of the court is justified by the end, by the purpose intended. So, as far as the communication to the public, this autonomous notion is at stage. The first act is the Sky case, the one which you may know because it's about an hotel, and the question, that was a Spanish hotel, and the question was, is there a communication to the public made by the manager of the hotel? The answer is yes, and I will only focus on what is important for our discussion. The court explained in that decision that the right of communication to the public, the notion of communication to the public supposes two elements, an act of communication and a public. And the court precises that an act of communication is any transmission by any means. So it is a very wide definition. And we find in that decision also that there is a role of the essential role of the person who acts. The court also takes into account the profit-making purpose, and as far as the public is concerned, the court defines it like indeterminable number of potential viewers. Act 1.5 del Corso case, I will not go in details with the facts. That was about a dental practitioner. And here you find the same definition, the same two elements. But the court go on with the precision of what is an act of communication and how to characterize it. And it emphasizes the essential role played by the user, the deliberate nature of its intervention. As far as the public is concerned, the definition is quite the same. Act 2 is Svensson case, because I'm focusing on this question of hyperlinks. And this is the case, the first case where providing hyperlinks was a question. Is that a communication to the public? When someone is providing an hyperlink pointing to a protected work or not? And the court here goes on to recall the two elements composing the notion and states that providing an hyperlink is an act of communication to the public. But at that stage, it distinguished two situations, because the act of communication when providing hyperlinks is a second one, because the work is already made available on a website. So the court distinguished if the second communication to the public is made by the different technical means, okay, we have to see, we have to verify whether there is a public or not. But if the second communication is made by identical technical means, then you do have to verify not only if there is a public, but a new public. And for example, this notion of new public is nowhere in the legislation. Okay, and the court go on, okay, providing an hypertext is an act of communication to the public. It is by the same technical mean. Why? Because it is internet. We can discuss of it, because it is not. The court made no difference between the nature of hypertext links, but there are a lot of sorts of hyperlink. And for the court, there is no new public, because the public of an open site website is all internet users. So the public of another website, freely accessible, is all internet users. In that case, we do not need the authorization of the author. That is an exhaustion of the right of communication to the public. However, in the legal text, in the Directive 2001/29, there is an express provision that say there is no exertion of the right of communication to the public. Okay, I will not speak about the GS Media, and the last act, if I may say so, is that whenever there is no hyperlinks, like in this case, that was a child making a presentation, picking up a photo on internet. The school made available this presentation on the website of the school, and then the question was, the school was making an act of communication or not? And the court, in that decision, said, okay, the public of one website is not the public of another. So she totally changed the way of seeing the new public. But she reminds, it is only where there is no hyperlinks. Why? Because in the first case where hyperlinks are in, the court wanted to ensure the communication freedom, the functioning of internet. In the other case, there is no risk for the functioning of internet. So for her, the purpose was to ensure the preventive nature of the right. Okay, I will not go, and I will end it here. And if you have any question, I will be pleased not to answer to it. Thank you.
Thank you very much, Stephanie. If I may add something, I think maybe the difference between Svensson and Renschkoff is also what authors can do technically, because if it's a hyperlink, you can simply kill all the hyperlinks by removing the content. But if it's copy and paste, there's nothing you can do technically. So legally, you should be able to sue.
That's it. Yeah. But what is really sad, that is, to be protected, the author has to remove from internet. But you're right.
Unfortunately. Well, thank you very much to both of you, Stephanie and Ignacio. And we will move on straight to patents and discuss the unified patent system and the, unitary patent and a unified patent court. And I will turn to Emmanuel at this point. So Emmanuel, can you remind us how the system came into force? What were the main points that were discussed?
Thank you. Thank you, Caroline. Yes, trying to do this, and by way of introduction, my day-to-day job is I'm a patent litigator, and I have a sort of second hat, which is I'm director of the program on patent litigation in Europe at SAPI. But being a patent litigator, it means that my role in a way is to convince a judge in a given time. So, Caroline, I need to know how much time I have here to try to convince you about the relevance of the new system. Why do I say that? Because I think that you will see that what we call the UPC has been a sort of long-standing story. It has been for about 50 years now that it has been discussed and then finally obtained. Who knows what the UPC stands for? Do you know what UPC is? Are you familiar with it? Probably yes, I would assume. So, so far our day-to-day job as patent litigator has been to try to enforce patents in Europe, basically. Because obviously if you get a patent, you'd like to be able to use it and to enforce it. The challenge, but the joy of it probably, has been that we had to, and still today, to play together with colleagues in Europe. Interaction, coordination. Why is that? Because, as you know, what we call a European patent, what is a European patent, as we know, is basically a single point of entry when it comes to application and grant of the patent. But then we all know that then it splits into a bundle of national titles. So basically, it's one point of entry, but then, thank you. But then it's split into national titles, which means that then you have to litigate country by country. There are, of course, you would find exceptions. But so let's take one or two examples. So, for example, I'd been involved in a case where you would know Scania, the trucks. You would know Volvo, probably. So two Swedish companies. So you could say, well, two Swedish companies, fine, they probably like to enforce their assets in their home country, in their home jurisdiction, i.e. Sweden. So if they apply and get a European patent, that they would somewhere in a single point, in a single seat, get a result when it comes to enforcing their patents. So for example, here we were in a case where basically a truck, one of the challenge for the truck companies is to limit fuel consumption. Why is that? Because obviously that's one of their main spends. So, and the second challenge is obviously that we all know that we want to reduce fuel consumption not only for economical reasons but also for the environment. So all truck companies, like also automotive at large, have been working on technologies about reducing fuel consumption. Volvo and Scania had 5 patents around reducing fuel consumptions by, without entering into the details, finding new ways to reduce by about 20% the fuel consumption. They've been fighting. Volvo has been suing Scania, Scania has been counter-suing Volvo, and so forth. Where have they been litigating? In Sweden, in Germany, in France, mainly. Why is that? Because obviously it came to litigating national titles. So what is new there? And I don't know whether I can scroll somewhere here. Can I use it here? Does it work?
It's better to...
No, that's fine. I will... you know what? I think you will find the slides, and I will try to do it just as a talk here. And yeah, that's you can go. Yeah, that's fine. Thank you. You will find it then. I'm sure you will have the slides. Would you? Okay. So basically, the challenge has been to create a system where, basically, based on 2 pillars. One is how to achieve a system where you can build the European market and have a unitary title, which is not only a single point of entry, but then also a single title which apply equally everywhere in Europe. Which, in other words, mean also that if you challenge that title, if you look for revocation or nullity of the title, that will destroy, in a way, the validity of that title everywhere in the same territory. So there are pros and cons, obviously. The second element is, even if you deal with traditional European patents today, as I was saying in my example, you have to go and litigate in every relevant country where you want to protect and enforce your patent. So the challenge has been to combine the two. A, create a unitary title, and that's what we have with the European patent with unitary effect, so-called unitary patent. The second one is putting in place, and that has been really a challenge, single court. And that's what has been created with the so-called unified patent court. That would be a court which decides for a given European patent, and obviously in relation to the countries in which the patent has been validated, has been granted. And then the decision will be enforceable in all the countries covered by the patents, and question mark whether it goes beyond. Well, potentially yes, but in reality no, because if you have validated your patent for 4 countries, France, Germany, I was about to say the UK, but I'll leave the UK aside for the time being, and the Netherlands, then you will enforce it in these 3 countries, France, Germany, and the Netherlands. So that's for trying to set the scene. If you scroll down a bit, yes, thank you. Another one, maybe, further down the road here. That's good. And then we go to the next one, further down. Yeah. Yeah, and down still here. Yeah. Again, if you go down here, next page.
Next page.
Sorry? Oh, you can go down. Yeah, that's good. Okay. Just few words here. I think, yeah, in a way, you will find on the slide the different steps about the negotiation. I think, without entering into details of these negotiations, interesting is the way the system has been adopted. I mean, what matters obviously is how it works. But interesting also is how it has been adopted on what legal basis. And it's based on this so-called enhanced cooperation. And there's a limited number of projects which in Europe have been set up and adopted on the basis of these provisions. And why is that? Is that not all European countries have been willing to join and create the system. Spain has been one of the no-go country in a way for, I was about to say dark reasons, but I would not enter into this, but for reasons which in my view are not, I mean, one is a good one, the language, but I think that behind the scene, but you will tell more about it.
No, just one clarification, because I was the person negotiating. And Spain never said at the beginning, that the Spanish should be official language. Spain said English.
I know.
Should be the official language. So
Exactly, I know.
No, because
Exactly.
there are a lot of
But my perception, but it's a very personal view that behind the scene also it's like all these sort of negotiations. Sometimes you have players, stakeholders who have also their immediate economic benefit for changing the system or not. But that's another story. So Spain is not in there, Croatia is not in there, and Poland is in between. But Poland, at the end of the day, is not within the system. And the UK, obviously, is no longer within the system. The system, I think, it's been really a true European project with probably few, leading countries. Germany, obviously, has been one of them. The UK, clearly, has been one of them. And France, to a large extent, as well. And Spain and others as well. So the system reflects probably a sort of mix of a number of the jurisdictions which have influenced the system. I shouldn't forget also Italy. Italy was not part of the system, but then joined later on and is now part of the system. So, what are we talking about as a matter of, if I'm late, you tell me, Caroline. If you go down the road here again and again, this one, the map, the preceding one. The preceding one, the one before. Yeah, that's fine. Yeah, I think what we want to show here is which are the countries within the system. So you can see in blue the countries which have ratified the system, and I say ratified because the agreement has been adopted. Well, I say the agreement, the Unified Patent Court Agreement, which is an international agreement, so it's not per se a European Union tool, or it has been based or linked with the European Union system, and the whole system is under or has to comply with European law, but it's the result of an international agreement. So it's the Hague Convention and so forth. And in 2013, the system was signed by the countries, by the 20, at the time, 6 countries, was it? And less, the UK now. But then you had to enter into ratification system. And that's when the mess starts, in a way, or the second, or the following step of the mess start, in a way. Why is that? Because some countries like Ireland, for example, need to go through a referendum. But do you think really, patent law should be within the hands of a referendum? I don't think so, but that the way it's national law. Then Germany, they had 2 claims with the Constitutional Court, Bundesgerichtshof, Bundesverfassungsgericht, and which delayed the whole system, and so forth. And again, without entering into too many details, the system had to be ratified by at least 13 countries, and within these 13 countries, by at least the 3 countries in which, before the signature of the treaty, in the countries where there were the highest number of patents grant or patent application. So that at the time would have been Germany, France, and the UK, but since the UK left, then it has been Germany, France, Italy. Anyway, so a bit complex, but at the end of the day, what should we keep in mind as to what is the system? If you go down the road here, the next slide, maybe again, yeah, maybe on the preceding one. No, preceding. Yep, thank you. This chart shows the timeline. But basically, what you have to bear in mind is the date of the 1st of June 2023. All what's before then is interesting for the sake of your knowledge about the system, but as a matter of fact, what matters is what has been done since the entry into force or the start of the court on the 1st of June. Before then, it was the sort of preparation and being ready for pressing the button on the 1st of June 2023. So the court is up and running now. And on the next slide, I think that we see, well, the countries, but then the one after this one. If you go down the next slide. No, yep, thank you. So this one is interesting because what does it show? And that's on the UPC website. It's a 2-layer system, not 3. There's no Berufung, there's no Supreme Court, there's no Cour de Cassation, it's 2-step, full stop. Yeah. And there's no sort of 3rd layer, which would be the Court of Justice. But the Court of Justice, nevertheless, it's a very subtle system in a way, is around there. And the court, the Unified Patent Court, has to comply with European law. This is very clear. Everywhere in the preamble of the agreement, under Article 24, which is the hierarchy of norms, you will see that European law is at the top. So clearly, it's not a court, because that's what we hear sometimes. No, it's not a European court in the sense of a European Union court, which is true. But at the same time, the court has to comply with European law every time, every day. It's one single court. It's not, that's what we hear sometimes, and to some extent it's a bit true, but it's not a complicated system. It's a simple one. You have one central division, and you have local/regional divisions. The central division, its primary task is to deal with revocation, validity of the patents, plus also infringement cases in some circumstances. Local/regional divisions have to deal with all the infringement and counterclaim for revocation, basically. It's a very rough summary. It's more detailed than that. The court has exclusive jurisdiction. What does it mean? It means that at the end of the day, after the transitional period of 7 years plus potentially up to 7 years, when it comes to litigating European patents, whether it's the traditional European patent, i.e. the bundle of national titles, or obviously the unitary patent, the only court in Europe which will have jurisdiction is that single court, is that unified patent court. First instance with the central division and local/regional division, plus second layer, the Court of Appeal, there's only one, based in Luxembourg. And that's it. And I like to present it that way because I think that's what our friends in the US, in Asia, outside Europe, like to hear in a way. And that's the way they look at Europe. They look at a one place where they want to litigate, or at least it's not about litigating, where they want to enforce or protect their asset. And yes, they know that there's Spain, they know that there's Germany and France and so forth, but they look at it by territories, the US, Asia, Europe, primarily, and then, yes, South America, and yes, Africa, and so forth. But when it comes to patent litigation, it's primarily these 3 sort of territories, with huge competition with or between these jurisdictions. I should stop probably very soon, just to let you know what we have on the following slides. If we go down there, interesting are these ones. You will look at it. We're about to reach the 100 cases filed with the Unified Patent Court. Where have they been lodged? Primarily in Germany. Germany has been very good at promoting its local division. Germany is the only country where you have more than one local division. There are actually 3 local divisions, Mannheim, Düsseldorf, and Munich. As you can see on the chart, 80 or 70 or 2/3 of the cases have been filed in Germany. And then you have a few cases filed elsewhere. And to finish here, if you go down to the next slides, you will see the apportion by sectors. I think that's an important one because it shows also that all kind of industries have been jumping into the system, unlike what was said before the entry into force. I will stop here. If we have more time later on, I can tell about some of the cases that have been already decided. But I think that's it because we obviously want to also hear about the unitary patent as such. And so I've been probably a bit long.
Thank you very much, Emmanuel. I think it takes a lot of skill to present such a complex, I think it's complex, such a complex system with such clarity. And now I think one of the key issues that you raised is the Court of Justice. So what role is the Court of Justice going to play in this system? Alberto, you have the floor.
Merci. Thank you very much, and thank you for inviting me to participate in this panel, and also thank you, Caroline, for your nice presentation. Well, now, after the Emmanuel speech, you know even much better than myself the new unitary patent system. And you know that you can get a unitary patent system applying for first European patent, the classical European patent, and then requesting for a new unitary patent. And one of the great advantages of this new patent system is that you can enforce this new patent, as Emmanuel said, in all countries participating in this scheme. And of course, as you can imagine, the question of enforcement has been actually one of the most difficult matters when creating the unitary patent system. Granting a common patent is one thing, but to develop a common jurisdiction is something much more complex. Such complexity is still higher because of several factors. First, because the fact that the Unified Patent Court covers, I would say, only the unitary patents and the classical European patent, but for the time being there are no clear links with the national jurisdictions. That could be, at the end of the day, a problem. Second, because of the political divergences with countries in and countries out of the system. And also because the new scheme has introduced the opt-out mechanism that is also necessary, but is also creating some additional difficulties. Third, because of the special nature of the new court. As you already know, the new court are not pure EU tribunals, are international tribunals. It's true, as has been said, that there are a lot of mechanisms, a lot of statements saying that they have to apply Article 20, 21, 22, they have to apply and to respect the EU law, and they have to request for the EU Court of Justice request for their views when they have some doubts. That is something I will come back, if I have time, later. The issue is that for political reasons, they are not pure EU courts. Therefore, all that, you can imagine, have created a complex scheme. I am not going to talk about that, but we have patents that are under the new jurisdiction. There are patents that will be under the national jurisdiction. There will be patents that could be in both. It could be at the beginning under the unified courts, and immediately there will be some effects on the national systems and so on. Then, as you can imagine, this complexity is going to have an effect that the specialists like Emmanuel are going to suffer in practical life. As I said, there are some question marks and some doubts that for the time being we don't know exactly how they are going to be managed. Let me now go into details and also to provoke a little bit. As a question of matter, it should be clear for all of us that the advantages of the new system are significant, mainly in matter of time, with a very short time frames to adopt decisions, flexibility, and a high level of specialization. And it's clear that step by step, the new courts will improve and align judgments that will represent a great advantage for industry. That should be clear. It's a new jurisdiction. It means a new possibility for protecting our inventions, for defending our patents. But there are some, as I said before, some question marks and reflections that had to be done. The first reflection is connected to the huge number of UP courts with different levels of training, legal traditions, specializations, and so on. It's clear that an additional effort to get a good convergence and coordination among them will be key for developing an efficient and coherent jurisdictional system. You can tell me that all that has been already considered in the preparatory works, and you are right. And you are right. But the final result will depend on each court, and courts are, by definition, independent. A few weeks ago, we had here a nice seminar on this matter. I remember the answer from a member of a unified court that was in our seminar. She said, clearly speaking, yes, but don't forget that we are judges, and judges are, by definition, exactly the expression she used, independent. And coordination also means, and this is my second reflection, the possibility to bifurcate questions to another court. For instance, to the central division when they got a greater specialization or there are some connections with other cases. This kind of coordination should be developed, but my question is, are the new courts ready to cooperate in such a way with other courts? We asked this question to the judge I mentioned before, and the answer was a little bit unclear. Therefore, wait and see what is going to happen in future. My third concern is linked to the nature of the courts. As you already know, the UPC are international courts. This is not a problem by itself. But because of that, some professors are asked themselves which will be the role of the EU court in the development of these new courts. I am not talking about the principles that you can find in the agreement. I am talking about how both courts, the unified courts and the EU Court of Justice, are going to put together and to work together for developing the future European patent system. How the EU Court of Justice can get a relevant role in the work of these new courts. As you can see now, when I said that there are some question marks or some reflection that had to be done, I was not exaggerating talking about the complexity of these question marks. Furthermore, we should not forget that the new system combines the different types of legal sources: international law, EU law, and national law. International law, the agreement itself, and the European Patent Convention are both international law. EU law, of course, because EU law inspires the whole system, and its rules have to be taken into consideration. And national law, in some cases, for instance, when we talk about compulsory license. This obligation is going to introduce some complexity too. The theory is clear. The UPC agreement established the primacy of the Union law. Article 20, the obligation of the new courts of cooperating with the Court of Justice, Article 21st, and so on. However, we should not forget that in practice, the influence of the EU Court of Justice will depend very much on the UP courts, mainly if the UP courts file preliminary questions to the EU Court of Justice. And probably, before adopting any decision in that direction, the court will take the economic interests of the different members and parts into consideration, because it's one of the reasons of their work, and they need to have, let me say, clients. Therefore, before going to the EU Court of Justice, they need to know the view of the different parties. And at the same time, we can imagine that industry and patentees will not be too much in favor of giving to the Court of Justice the opportunity of being involved on patent cases, because that could represent additional time, money, and maybe less security. Therefore, as I said, there will be some reflections to be done on that. Another key issue is to try to understand how the new patent system is going to cooperate in the development of the EU patent model, and therefore to facilitate European convergence. Let me be even more direct. Because of the special nature of the new unitary patent system, my open question is to know who is going to develop in the next future the patent policy for the internal market, for the European internal market. Who is going to fix the guidelines for the development of law and jurisprudence in patent matters? In my view, in my personal view, nowadays in Europe, the UP courts and the EPO are the real patent bodies. However, both are international bodies, are not EU bodies. And as international bodies, they can maybe develop their own political ambitions. Therefore, once again, I underline the need to establish clear links between EU institutions, than the Court of Justice and the new courts. And Caroline, looking at the watch, I think I should stop here, but I'd like just to finish with one reflection. We should think, and probably in Brussels they are already thinking about that, who is going to drive the evolution of the patent law in Europe. Of course, the unified patent courts have an important role to play. The EPO has also an important role to play. I was talking with Caroline before, and a couple of days ago I have a nice talk with one of my former colleagues at the EPO, and he mentioned that they are looking for experts that could use German and French in the new court, because they have some difficulties to find this kind of experts. Then the EPO, for sure, is a very good body, by the way. But what happens with the other institutions? EU Court of Justice. At the long term, maybe, but for the time being, there will be a long process before arriving to a clear conclusion. And why not other EU institutions? Why not, let me say, I want to provoke once again, the EU IPO that now has some competencies on patents. Or why not all together? And they can cooperate to develop the future patent law on the internal market. Well, as you can see, this new system offers together fantastic opportunities. Yeah, I agree with you. And also major challenges and many question marks that will be your role in future to take care of all of that. Thank you.
Thank you very much, Alberto, for all the issues you raised. I was going to ask you how likely you think the UPC is going to refer preliminary questions to the Court of Justice. If I'm not mistaken, it's optional for the Court of First Instance, and then it's mandatory on appeal.
Yeah.
Yeah. So how likely is that going to happen?
It's going to happen. The issue for me, the issue for me is not if going or not to happen. The issue is the time. That means we are going to have a very long time in front of us. You never know what is going to happen with the new court. There are different legal traditions. You cannot compare the German court with the Spanish one, because they have been working on patents for many, many years, and they have a long tradition. For instance, if you talk with our American colleagues, USA lawyers, they mention that they prefer to go to a German court and not to go to another one. Why? Because they trust in the coherence of the decisions adopted by these courts. If we think about that, you can imagine why I mentioned before that you never know what is going to happen with the other court, if the other court, for instance, are going to present preliminary questions to the EU Court of Justice, because maybe their mechanisms could be to be very quick to respect the new time frames when they adopt decisions. And this will be the way to be competitive if we are talking about competition. And this is also the reason why I underline that we need to reinforce the coordination among the different courts. I know that was one of the priorities adopted during the preparatory works. And from the very beginning, the authors of this system, they have this idea in mind. But one thing is to have the idea, and one thing is to know what happens in the near future.
Well, thank you very much. I think that's all we have time for, unfortunately, but we can continue during the break. You can ask all the questions you might have. So I want to thank all the speakers for this session. Thank you, Stefani, Ignacio, Emmanuel, and Alberto. And now it's time for the break. So we have 15 minutes, so we'll expect you back at 10 minutes after 11. Thank you.
Miguel, not yet, so perhaps we can start with the other intervenant. Is okay, Miguel? Okay. So we will start with the second roundtable of this morning, and I would like to again thank the speaker of the previous roundtable. It has been really very interesting. I hope the students from Alicante and Lille has been really attentive because they developed important issues on the different IP rights we studied in the master, and also we will have it in our exams at the Magister, so I hope you have really learned a lot and this morning. Now we have this third roundtable. First of all, the first part of the roundtable will be focused on really convergence programs of the offices. I would like to highlight, perhaps as a little introduction, as you may know, you know very well, intellectual property right in general. We have seen lots of different intellectual property rights today, this morning, and yesterday, and they are characterized mostly by a coexistence between EU, national, and regional titles. And the complementarity between those titles, I think, is essential, and it's for that reason we have seen, we have organized these seminars. Sometimes we do have a unitary title. We have seen it with different unitary titles here this morning and also yesterday with trademark, etc. Sometimes we have a coexistence between national, for instance, in trademark, national trademark and European Union trademark, but sometimes not, as is the case of, for instance, copyright, even if we have deal with the autonomous notion of the Court of Justice, and in other cases we have only the European Union titles, as is the case of geographical indication, even if it's not our topic today, but it's very close to my heart. So, after the panel dealing with the standing convergence vectors, namely the Court of Justice and the unitary patents and copyright topics, we will analyze now the convergence of practice in the different member states and also the convergence of practice between the national EU offices. And it's for that reason I would like to thank particularly the different European Union offices present today, also the Spanish trademark office, and also the police, the National Policía Nacional, the National Police of Spain, for being here, because I think we have a very good panel in order to see how those different offices and institutions helps for this convergence of practice at the European Union level. So we will start, first of all, with the EU IPO. I will introduce the speakers, and after I will give the floor to each one of them in order to know a little bit more about those practices in the different offices. We'll have first with us Mrs. Joana de Moura. Joana come from EU IPO Institutional and Cooperation Department. She serves at the Portuguese office INPI Portugal, dealing with convergence program at the national level. And after she joins EU IPO, where she has been appointed team leader of the convergence group at the European Cooperation Department. So you can see she's a real expert on convergence practice, as well as at the national level and at the European Union level. We'll have after the European Patent Office, and we will have the presentation from Michael Froelich. He's the director of the Patent Developments and IP Lab at the European Patent Office. He has been responsible for developing policy orientation and solutions regarding the international and European legal framework in the field of patents, including the harmonization of patent law and practice, so we can see the link and the importance for this seminar. He drives nowadays the convergence of practice programs at EPO, as well as activities in the context of the harmonization of practices at IP5 level. So, another big expert on convergence practice at the European Patent Office. After that, we will go through a national approach, and for that, we will have Lourdes Velasco, head of the area examination of distinctive signs at the Spanish Patent and Trademark Office. Lourdes has been a speaker in several courses regarding convergence programs at the EU level, and she is frequently at EU IPO in order to deal with the relationship between the national office and the EU IPO for this convergence of practices at the national level in Spain. And last but not least, we will have with us the presentation or the impression from Inspector Mrs. Maria Cirre Rodriguez. She is Chief of the Group 3 of the Section of Intellectual Property Crimes, reporting the Central Unit of Violence and Specialized Criminality for the General Commissary of Judicial Police of the Spanish National Police. So you will see with these speakers we will have a very good approach regarding the different convergence of practices at the EU level. So first of all, Joanna de Moura, you have the floor in order to start with the EU IPO perspective. Thank you so much.
Thank you. Thank you very much, first of all, for the invitation and for having me here to share with you and have this excellent opportunity to share with you what we do in the Convergence of Practices team in the EU IPO, and always in collaboration with the national offices and also the user association. So when we speak about convergence, we speak about harmonization. And when we speak about harmonization, we should have in mind the different layers that exist in Europe and to which extent they are legally binding for the IP office. When I refer to IP office, I will refer to the EU IPO, national office, and also the user association. So the group, we call it always IP office. So we have the legislative layer, and this is determined by the provisions in the Trademark Directive and the Design Directive, which they are legally binding for the IP office because they have to transpose these provisions to their national law. Then we have the case law decisions that are issued by the European courts, and these determine the correct application of the legal provisions, for example, the preliminary rulings, and they are also legally binding for the IP offices. And then we have the third layer, that is the convergence project. So the need for convergence arises from broad national laws, so legal provisions that gives or leaves room for interpretation. And of course, when we have different interpretations from the different EU IP office that transpose the law, what happens is that we end up with different outcomes, okay, which leads, of course, to different practices, and this will affect legal certainty, predictability, clarity, and transparency of the IP system. So all the activities that we do in the convergence of practices in the EU IPO follow under this third layer of the convergence projects. So the convergence projects were launched in 2011, and they aim to develop common practice. This is our main goal, common practices, or if we prefer, harmonized guidelines, that they consist of common principles, recommendations, and they are centered always in a specific area of practice. It might be designs, trademarks, and within that we have absolute grounds, relative grounds, appeal proceedings, as I'm going to show you the list of projects that we work, that once they are agreed by all the EU IP offices, then they are implemented and adopted by this office. That means that in a moment that we agree all together in a common practice, this common practice converts in the practice of all EU IP office from that moment on. So in the topics that I'm going to show you, all of us have the same practice. And how do we decide which areas of trademarks and designs we work on? So the topics are carefully assessed and carefully proposed to be launched as convergence projects. And we have to take into account a number of factors, such as the level of interest from the users, the number of cases that we have in the IP offices, because we don't launch projects if we don't have enough trademark cases, the degree of divergence that is identified through questionnaires that we sent out to the national offices, the existence of legal impediments. If we have legal constraints, we cannot launch a convergence project so that we work on a common practice because there's law impediments. Recent case law issued by the European courts, so the most recent case law which will impact the practice, this is also very important, and of course the potential benefits that the common practice will bring. If there's no benefits, there is no interest to have any convergence project. How do we draft this common practice? So these common practices are drafted by a working group that is composed by the different IP offices, 2-3 max user associations that also participate in this group, and the EU IPO. So we believe that to reach agreements, we need a small group. Once we identify that the common practice is ready in a determined area, we discuss it with the extended working group, which means that we have a meeting where all the EU IP office will be invited, where all the user associations that work at the EU IPO are invited, and the non-EU, so that we have their agreement too. So you can imagine already the challenge that it is to have everybody discussing these documents, but it's very important that the common practice always have the different perspectives of all the EU IP offices and also the non-EU. And this is why when we select the working group members, we select, take into consideration, of course, their expertise and skills, but also proportionality, balanced geographical distribution is important to have the different point of views from the Nordic countries, the South, so all of them collaborating for the drafting of this common practice, and of course involve the different schools of thoughts. So where are we today? So in this slide you can see all the common practice that we have worked on and adopted so far since 2011. Important to note that this common practice, they take each of them the duration of 2 years to conclude. So it might seem that it's a short list, but in the end it implies a lot of effort to manage to draft this common practice and have the agreement from all the stakeholders involved, as I already mentioned. They have been extremely well received and widely implemented throughout the EU. And I must say that we have 92% of implementations at the EU level, meaning that these implementations and adoption of this common practice, they are voluntary, meaning that they are not imposed, and we have got this 92%, which means that there is a huge interest, and this is evidence of the value that this common practice have for the IP system. So we can see the first two common practices, they are on classification. And they were very important back in time in 2011 because they tried to reach an agreement at the EU level on the interpretation of a very important preliminary ruling that was the IP translator. Then we had a common practice on CP3. This was in particular to agree on when a figurative mark that contains a word that is non-distinctive or is descriptive, consequently non-distinctive, because of that figurative element as a whole is distinctive, so passes the absolute ground examination. CP4 in the scope of protection of black and white marks. So when you have a trademark register in black and white, does it cover all colors? And we have, so what is the scope of protection of black and white marks? So we have taken into consideration priority claims, relative grounds, in particular identity, Article 8.1a of the regulation, EU regulation, and also proof of use. If a trademark in black and white covers all colors or not, is that genuinely used or not? A very important one, and still we are assessing all the case law in relation to this project, is that when you have in inter-part proceedings in opposition or invalidity on relative grounds, an early mark and a contested mark, and both share common components that are of a low degree of distinctive or non-distinctive, what is the impacting lock or not? So all the rationale of whether this trademark should coexist in the market, whether we should not, and the stricter approach should be given. So this is what this common practice is about. CP6, the first convergence project in the area of designs. This was also extremely important because it agreed on issues such on how to represent correctly the design. This is the main point, but on issues such as the visual disclaimers, the type of views, how to reproduce on the neutral backgrounds. We had issues where color, we didn't know, in some IP offices were being used as a feature of the design because it's included in the definition of a design, or whether it was being used as a visual disclaimer. So we want to exclude that from the design protection. So this project aimed to agree on that. So for now on, we know when we use colors what that refers to. CP8 on the proof of use, so use of a trademark in a form differing from the one registered. We know that the holder of the mark has the right to modernize his mark, but when do we consider that it already alters the distinctive character and is no longer the sign as it was registered? Okay, so these are the considerations. Also another project on three-dimensional marks. Another one very important also on designs that tackles the issue of evidence on the internet and how important that is, how to prove the evidence on the internet. So this is extremely important. and one that results, that's the result of the legal reform, that is a new type of trademarks, the examination of formal requirements and grounds for refusal, and to finalize the project on appeal proceedings. So as you can see, there are several. For time constraints, I cannot develop more. I will show you what we are working now, even though, of course, we are always updating and checking the other projects that I've shown in the previous slide. These are the ones that we are working now. CP13 on trademark applications made in bad faith, very important also as a result of recent case laws, the monopoly, so tackle issues of refiling, misappropriation of third-party rights, abuse of trademarks. So you might find very interesting collection of the most recent case law and also guidelines in this aspect. CP14 on trademarks contrary to public policy and acceptable principles of morality, also important, and took into account the last case law, the fuck you get, if I pronounce it correctly, and also takes into consideration the developments of the freedom of expression, the increase of the trademarks related to cannabis, so all these considerations were taken into account. CP15 on the comparison of goods and service, but now on the perspective of relative grounds, on the treatment of terms lacking clarity and precision, canon criteria, and the last one on subject matter that is related also to the title of books. So as you can see, we are quite busy and we have several projects ongoing. And I would like now with this slide to show you the impact of this common practice. So I will focus now on CP3. That was the third project that I've shown you in the two previous slides. So this project is on the absolute grounds when you have a figurative mark that has a word element that is non-distinctive and is descriptive, and when, due to the figurative elements, it passed the absolute grounds examination. And you can see blue dots. So the blue dots represent the practice before the project was launched. Okay, so these were the practice of the IP office. So you can see we have offices such as the Danish office and the Portuguese office that they were accepting a lot of trademarks. Okay, so they were considered those trademarks distinctive. But then we had offices such as the German office, UIPO, and Ireland that they were refusing a lot of trademarks. So of course that this creates uncertainty and undermine legal certainty and predictability for our users of the system. So if you want to file this trademark in Portugal or in Denmark, unless you have this graphic we don't have for all the areas, you don't know what you will get. And this creates a lot of uncertainty. So our purpose is then to work on these common practices, to draft guidelines in relation to that, take into account the most recent case law, use examples that are inspired on the recent case law so that we can reach a common practice at the EU level. And this is what you have now in the red dots. So the same questionnaire was sent out, which include 100 questions. After the common practice was adopted, and the practice that we got from all these offices is what you can see in the red dots. So I think this is obvious and shows the legal certainty that really increased with this common practice, because of course we cannot eliminate the divergence, that's impossible, especially in IP due to the subjectivity. Also, we always put in our common practice, this is always a case-by-case approach, but we can reduce it substantially, and that's our intention. We aim to be more predictable so that the users know what they can predict from the outcome of the decisions in the different jurisdictions. Also, the users know, and the applicants, that they might get the same scope of protection throughout the EU in these determined areas, and clarity and transparency, because all these common practices are then translated in all the EU languages. They are available in the website of all the IP offices, also in our web page, so you can always consult in your own language, which is also a benefit. To finalize, because I believe that I'm running out of time, I will just show you another project that is on the new type of trademarks, and this is a result of the legal reform where there was the elimination of the graphical representation from a trademark. So we end up basically with a directive eliminating but not proposing definitions for the new type of trademarks, representation requirements, and which file formats can be accepted. So what we have done was a pre-legislative convergence and a post-legislative convergence, as we said. So to avoid divergence of practice from the outset, we have created another working group, a common practice on the new representation of trademarks, where all EU member states have agreed that we will accept this type of trademarks. These will be the definitions. We have agreed on the representation requirements and the file formats. And based on that, this was done before the end of the transposition, so we avoid the divergence from the outset. And we have used that opportunity that in a moment that the legal reform was over, we immediately launched another one that is CP11. So this paved the way to agree and go a little bit further so that we all in the EU level agree on a common practice for formalities, for agreeing on when do we consider a sound mark distinctive, so to reach agreement on AG, but also on relative grounds. How do we compare a sound mark with another sound mark, a sound mark with traditional trademarks? So we have several examples and guidelines based on case law also on this area. And as you can see, we moved from June 2018, where non-IP offices have any guidelines whatsoever on this, to have guidelines for the entire EU. So I think that it's a clear demonstration of the value that this common practice have at EU level. Thank you.
Thank you so much, Joanna. Thank you for your presentation. Thank you to EUIPO for the impressive work, particularly with this last slide. You show us how before having even the regulation, we do have common practices, which I think is incredible and is very useful for everyone. I mean, for all the stakeholders in this field, particularly trademark and designs. And I think we will move to a national office, because even if I think we have EPO, as I am not sure, because they are having some technical problems, that's the point when we have online speakers, sometimes we can have this kind of issues, but we will solve it. But we move on to the national office. We will see how those convergence programs will be developed and implemented by national offices, and also the activities they've done regarding those programs. So for that goal, we will have Lourdes Velasco from the Spanish Trademark and Patent Office. Thank you so much, Lourdes. You have the floor.
Thank you very much for the invitation, and thank you, Joanna, for your explanation. So I have to speak past brief at the first slide. Please, Sora, continue, please. Please. Because, yes, no, implementation. Quite implementation. Because it's the moment of the procedure when the national office introduces all the common practice. And how is that the implementation? We receive, if you see the common practice document, also you can find a special communication when explain what is the process. At first, the IP office sent to a WIP executive director a letter of intent to implement a specific common practice. The second, the IP office establishes and communicates an implementation date and confirms which proceeding will be affected. The conversion of practice team will provide training material when available. And 3, the conversion of practice team includes any new information of the implementation table of the relevant common practice and notifies the public. 4, the IP office applies the common practice where applicable. Setting the common practice within decision is recommended. That perhaps is more difficult for the national office to put in practice those sentences. At first, at the beginning, when you receive the communication, and the material training, all the examiner, you prepare a group for information, because all the examiner have to know what is that document. And if anyone have a problem, you can explain, and you can looking for other similar case in Spain, because normally in the material training you have many examples. But sometimes it's very difficult to find a very, very similar example. Why? Because normally the example are in English, because we need that everyone know the situation, and everyone can use the same idea about the sign and the product and service. And for that reason, for example, in Spain, majority of the case, the people, the applicant, don't use the English language. So, but that is not a special problem. We try to compare with the possibility, perhaps with the color, no problem. Perhaps with the figurative forms, no problem. So it's important, and it's good that common practice for our examiner. We put, all national offices have to put in the website that common practice, and everyone can read, can use that common practice, not only the national office, also the user association, the people who is the representative of the applicant, or inclusive the applicant can consult in our web page each common practice, no problem. But about the material training, sometimes is difficult for us. Why? Because normally when you are using a material training, but that material training is not the official of the communication, we must be careful, because perhaps we have prevention, a big prevention about the use of that material training. But for our examiner, we have in our web a special position for all that material training. And each year, the examiner receives information. And when arrive new examiner or new civil servant in the department, have to pass the course about that information. And normally now, when you finish the course, you have to pass several questions. Not only you do the course, you after receive a question and you have to pass that questionnaire. So for the office, that is good, because you realize that the people understand or don't understand that explanation. The problem about, no, please continue with the implementation, sorry. Implementation. Yeah, okay, thank you. The problem when setting the common practice within decision is recommending, okay, is a good recommending, but for national office, normally the Spanish office, normally don't write that sitting with normally, no, but we explain and our resolution is according to the practice. But when you aren't accord with our resolution, after normally our office, yes, sitting the common practice when resolved after the resolution is more normal than in the resolution. But that doesn't mean that we don't use that material. And for example, one curiosity things, when we have to complete the questionnaire, sometimes it's very difficult. Yes. For example, about distinctive, nor distinctive, you can see many sardine, and normally it's for using for sardine. And you can see in the example, sardine in word and figurative and inclusive. One of the examples I remember was is perhaps one of the letters, sardine, bright with little sardine. and sometimes you think, how many times I found a guy's application very similar with us. It's difficult sometimes, but that example is good because it's easy to understand the idea. Sometimes it's difficult to find similar situation, but it's better for understanding what is the idea, the essential common practice. So, but when you are resolving and you are answer the questionnaire form, sometimes you see, I finish, I see several Gary Van or several names in many positions, in many cases, for many things. But always I think that the principal idea is to understand the objective, no? The subject matter. Yes. But when you have to translate the Spanish is when you must be careful when you explain. Because some people say, I never see this problem. No, you see this similar problem. Okay? But it's a personal question in Spain with it. And I think that I explained about, for example, the first CP1, please. CP1, continue, please. Okay. No, continue, please. The first, continue, please. Sorry, continue. Yes. That is a good example. Yes. Acceptability of classification terms on the general indication of the needs class heading. Good and service should to be identified with sufficient clarity and precision. Well, traditionally, the normal is you and all your products was an administrative law, and for many people, the important was the science, but the classification has less important. But now about, for example, thanks for this common practice, the classification have a more important level that was in the past, because you can refuse your application if you don't have a good classification. And the problem the classification, one is good and service should to be identified with sufficiency, clarity and precision. Perfect. But what means clarity and precision? Because perhaps if I write my product is that, perhaps in service it's more difficult, but about goods it's easier. But the question is that, for example, clothing. What is the natural class of clothing? The natural is 25. But you can find clothing in the 9th class, in the 10th class, because are special clothing, material clothing. So the first level is the natural and normal meaning of the word. That is the most important. But how can you resolve when you are in not a special natural situation? You must go to TN class. TN class is the harmonization database. And you can find, no, era in sorry. Yes, that's TN class. Why? Because if you write, you can discover what is the perfect classification for that special clothing, and you resolve the problem. If you don't resolve, you can use similar situation. Up, you can see machine. Why? Because we are members of NIS classification, and machine today is in NIS classification. But how we are member, as we are member of the European Union, by the resolution of practice, common practice, convergent practice, we don't use machine, because machine is a word with less clarity and precision. Why less clarity and precision? Because you can find a special machine in different class, and you don't have enough information to consider the correct classification. Okay, bueno, it's one example.
Thank you. Thank you so much. Thank you very much, Lourdes, for this explanation regarding the big work done by the Spanish Trademark and Patents Office. It's incredible, and I think it's very impressive and very useful for all the stakeholders of the systems. Now we will try, because I know we have our EPO speaker is connected, but we are not sure if it will work, so I think we will try. I think Michael is with us, Michael Frolich. I don't know if we can. Oh my goodness. That's great. We can. Okay, so let me please introduce Michael again, even if I did it at the beginning, but he wasn't there. So as I told you, Michael Frolich is the director of the Patent Developments and IP Lab at the European Patent Office. He has been responsible for developing policy orientation and solutions regarding the international and European legal framework in the field of patents, including the harmonization of patent law and practices. He drives the Convergence Practice program at the EPO, as well as activities in the context of the harmonization of practices at IP5 level. Thank you so much, Michael. Sorry for those issues. You know, when we are online, sometimes we can have those kind of troubles, but thank you so much for your patience and for being here for us. You have the floor.
Thank you so much, and I hope that the connection is stable and that you're able to hear me loud and clear.
Perfect.
Fantastic. I'm kind of doing this now through the phone since I had some technical issues for which I really apologize. So unfortunately, I'll not be able to put up the slides, but I understand that the slides will be shared with you after the conference. So I'll try to provide you an overview of what we at the EPO are doing in the area of convergence of practice. Very warm welcome, maybe to start with from my side as well. It's really my pleasure to provide you with this overview on the convergence program that has been launched at the EPO under the Strategic Plan 2023. We are currently confronted with the situation in Europe that applicants who are seeking patent protections have to face diverging practices before the national offices as well as before the EPO. And this obviously not only complicates the European patent system, but it's also costly and involves administrative burden. So quite similar to what you've heard from the EU IPO in relation to trademarks and designs, the program on the convergence of practice at the EPO aims at reducing and possibly overcoming these differences. And this should be achieved by setting common practices in identified areas, areas in which it could be expected that a more uniform approach would provide the most beneficial results for users and patent offices. And the common practice are inspired either by the practice of the national office or the EPO, and will be developed commonly and with input from the users through an approximation of pre-existing diverging positions. And I think this is of particular importance for small and medium enterprises, as differences in practice are generally a critical obstacle for them in operating at the European and international level. But we expect, or we see many other benefits flowing from the convergence of practice. For instance, the common practices contribute to cost savings for applicants, which could in turn be used for additional R&D and patent protection. It's to expect that harmonized practices also facilitate the use of earlier searches and thus enhance work sharing between the national offices and the EPO. Knowledge cooperation and training for the staff of the national office is also positively affected, and the better alignment of certain workflows in relevant patent procedures also has a positive impact on the harmonization of IT tools. And obviously, it also has the potential to strengthen Europe's position at the international level, as it facilitates for the EPO and the contracting states to speak with a common voice in global discussions. For instance, harmonization of practices are also undertaken at the level of the IP5 offices in the context of the Patent Harmonization and Expert Panel. And here it is also a goal in our future SP 2028 to elevate the common practices that we have developed at the European level to the international level. So the benefits are really manifold, and they concern users and patent offices alike. Now, how is this done at the EPO? Well, the actual work on convergence is done in working groups, which are composed of representatives from the member states, as well as the EPO. We have observers from the user side, Business Europe and the EPI, and WIPO is also participating since this year. The working group's tasks is to examine the existing practices in the various member states and the EPO, taking stock, so to say, of the divergences, analyze the disparities, and then engage into a discussion which eventually lead to an agreement on a common practice. That common practice is then submitted to our bodies and approved by the EPO's Administrative Council. On average, we have 20 to 25 states that participate on a voluntary basis in these groups. This ensures a pretty high level of participation. As said, the outcome of a working group is a common practice, which is then adopted by the Administrative Council and published also on our website. The time between the start of the work on a particular topic for a common practice and its adoption by the Administrative Council is pretty swift and quick. It takes approximately 15 months from the beginning of the composition of the working group to the adoption of the Administrative Council. Initially, under the Strategic Plan 2023, 6 topics were jointly identified for the Convergence Program. And these topics were selected jointly by the EPC contracting state, the EPO, as well as the users, following an extensive consultation process. The work on all of these 6 topics has in the meantime been completed, and common practices have been published in all of these areas. And I would like to give you a very short teaser and an overview of the content of these agreed common practices, of course, without going into all the details, but just to give you an idea what this is about. The first one that was developed, I should mention that the common practices, the work in the working groups is always done in pairs. So we roll out 2 common practices per year, so to say. And the first pair was on the examination of unity of invention and the practice concerning designation of the inventor. So as far as the examination of unity of invention is concerned, that one was adopted in December 2022, and it covers the information to be provided to applicants as a minimum reasoning when raising non-unity objections, including some definitions. In a nutshell, the information to be provided when raising a non-unity objection should include in the introduction to the objection, and where appropriate, a statement of the legal basis for such an objection and the identification of the different groups of inventions. It should also include the grounds for objection, including the common matter between the different groups of inventions or a statement of the lack thereof. As far as the designation of the inventor is concerned, which is the second common practice which has been worked on and approved at the same time as the one that I just mentioned, on the designation of the inventor, the common practice provides that inventors are not formally notified by patent offices about their designation in patent application, and they can instead obtain information about their designation from the applicant or through the inspection of the patent register or via file inspection. It also foresees that a certain amount of information, such as family name, given name, country and place of residence, are entered in the patent register. However, any additional information about, in particular, the inventor's full address is not published in the patent register. This is particularly also done since many inventors have received unsolicited letters using their private address that was listed in the register. Moving on to the next common practice that we have adopted is concerns the accordance of date of priority. That one was adopted last year, and it relates to the formal and administrative requirements of the accordance of the date of priority. And it's a rather complex common practices which includes 7 distinctive elements. It provides in particular that concerning the date of previous filing, the filing number, and the country in which the early application was filed should be published. And there should also be an exemption from the obligation to file a copy of the early application if the latter was filed with the office concerned or is available to that office from a digital library, such as, for instance, WIPO DAS. It also deals with translations of the earlier application, which should only be required if the validity of the priority claim is relevant to the determination of whether the invention concerned is patentable, and where a deficiency is noted, the office should send an invitation to the applicant to remedy the deficiency within a relevant period, and means of legal redress should also be available. Then we have a common practice on the re-establishment of rights. It was also adopted together with the one I've mentioned before, and it mainly relates to the formal requirements for the filing of requests and for the drafting of decisions and communications on re-establishment of rights. Again, very briefly in a nutshell, just a peek at that one, it requires offices to ensure the availability of information on loss of rights for the relevant parties. It identifies minimum elements for the filing of requests for re-establishment of rights, as well as minimum elements for communication or decisions on requests for re-establishment of rights. The most recent pair of common practices that have been adopted in March of this year are the ones on claim drafting and structure, and the one on the examination of computer-implemented inventions and artificial intelligence. Very briefly, the one on claim drafting and structure relates to the formal requirements governing the drafting of claims. It covers a number of areas, including aspects relating to clarity, conciseness, and support for claims, asking, amongst other things, that offices are to provide that the claims are clear and concise and are fully supported by the description, which is also in line with the provisions of the Patent Cooperation Treaty. But it also deals with the form and the content of the claims, the limit on the number of independent claims per category, requirements for dependent claims, number of claims, or as regards applications containing drawings, tables, and last but not least, also values and units. And then we have the one on CII and AI. For a start, it clarifies that while some jurisdictions have definitions for the terms of CII and AI, and computer program, there's actually no need to adapt a formal definition, as those terms have normally the meaning given by the skilled person in the art. It further lists that when examining these type of inventions, officers take into account a certain number of exclusions from patentability, and it deals with the various aspects of the required contribution as to the technical character or inventive step, as well as sufficiency of disclosure and the clarity of claims. I realize that this is now really hard for you probably to follow without any supporting slides. But again, I wanted to give you just a peek of at least the peak of the iceberg. If you're interested in more details on either one of these common practices, I would like to invite you to visit the EPO website at epo.org/convergence, where all the common practices and some further useful information is published. Now, the feedback that we have received on this first work cycle on the convergence program, the feedback received from both member states and users has been resoundingly positive, and was hence decided to continue the program with a new work cycle that started already at the beginning of this year. And for this second work cycle, the EPO had again identified, together with the member states and in consultation with the users, 6 topics that appear particularly suitable, since they mainly focus on administrative practices and can potentially generate the benefits expected from the convergence program. So it's really about soft harmonization. We're not trying to change the law. It's really an alignment of the administrative practice that leads to an harmonization and yields all the benefits that I've mentioned before. The first pair on which we are currently working concerns the formal requirements for drawings, as well as the second one is the issuing and accepting of electronic priority documents. The second pair, which will be then launched as of the beginning of next year, to be concluded then by March 2025, concerns the alignment of assignment practices as well as observations by third parties. And then the last pair, which we'll be looking at, concerns broad claims and the issue of double patenting. I think I will stop here and see whether there are any questions that you may have. I hope the few information that I was able to provide you was useful, and that I was also able to arouse your interest in these convergence matters at the European Patent Office. And with this, thank you very much for your attention.
Thank you very much. Thank you, Michael, for this excellent presentation. I can tell you that it has been really very clear, even if we have lots of information, but this will be really very helpful for our students, particularly for the students of the Magister Lucentinus, because as they are in the patent module, they will need to deal with those practices in order to better understand the patent law and the different regulation they need to study. And perhaps I know you have issues with your PC and phone, and we are so lucky to have you on board now. Perhaps if there is a question, we can have it right now in order to let you, because I suppose, I don't know if you will be there with us for the rest of the round table, just in case. As you are here with us, I don't know if we have a question for Michael. Otherwise, we will go through the other speakers. Okay, so if there is no question, I would like to, again, thank you so much. It will be really very nice for us to have your slides. I mean particularly for the students, because in order to understand the different information you give to us, it will be really very, very nice. Thank you for being here, even with those issues you have had with the PC. Thank you so much to you, to the EPO, for the great work regarding the convergence practices, and I hope we keep in touch for several other projects.
Absolutely, I'm looking forward to it, and thank you so much for having me. And apologies again for the technical issues.
No, not at all. Thank you so much, Michael. Have a nice day.
Bye-bye.
So thank you also to our colleagues, Jaume, Miguel, Álvaro, for helping us with this technical issues. And we will finalize this roundtable with, I think, a very interesting approach for all of us, because the police is always a very interesting approach, because we need to know how to deal with those issues afterward. And it's for that reason I give the floor to Maria Cirre. Thank you so much, Maria, for being here representing the police, the head of the IP section of the National Police in Spain. You have the floor.
Thank you. Good morning, everyone. I'm very pleased to be here today to participate with you in this roundtable. I work in the Specialized and Violent Central Unit, as Pilar told you before, in the Intellectual and Industrial Property Crime section. I'm going to tell you what we are dedicate ourselves to and how we work at international level. The section's competence, our section, is investigate intellectual property crimes, specifically Team 1 of the section. This team ensures copyright and everything related to intellectual property and hacking audiovisual signal. In Spain, IPTV, M3U lines and subscriptions have increased by 70% to the detriment of car sharing and other more physical ways of hacking. Team 2 fights against industrial property crime, specifically against tobacco smuggling. This team dismantles illegal tobacco factories throughout the Spanish territory, tobacco which its main destination is France and United Kingdom. Right now, it's one of the most lucrative business, taking into account that just one factory can generate a benefit of more than 2 million euros per day. The Team 3, on which I am the team leader, works exclusively against industrial property crime and connected offenses, organized crime, money laundering, consumer rights offenses. We dismantle transnational criminal organizations dedicated to importation and subsequently sale of products that violate industrial property rights. Our last action day with Vigilancia Aduanera, Customs Surveillance Service, took place last Tuesday against counterfeit sunglasses available for sale on prestigious stores. Our most important operational action this year was Quinto, Cinquième, still ongoing, in which we attempt to dismantle the head of a criminal organization that leads and controls the top manta in Spain. Top manta is an important problem, especially on the coast and tourist areas, that generates millions of euros per year and affects society in general. Intellectual property crosses borders. So we can't conceive work just at national level. We used to work closely not only with the most important European agencies, Europol, OLAF, Eurojust, but also with the rest of countries through a network of liaison officers, attachés. Especially in the frame of Europol, since intellectual property crimes is a priority, we participate actively in impact in order to fight with more strength against this kind of crimes. In particular, within the priority IPC3, we lead operational action Fake Star. This action is focused on combating and interrupting crime, whether the criminal organizations, companies, or perpetrators against intellectual property, which occurs during the phase of production, sale, or distribution of counterfeit products, physical and online. All this is focused on the typology of goods that are most frequently found and that are acquired by consumers in a broad sense: garments, sport clothes, shoes, leather goods, and accessories, as well as any other good that could be appeared next to the aforementioned. The objective of this action is to shed light as to why counterfeits of this type are of great importance, being many times related to other criminal typologies: intellectual property crime, organized crime, money laundering, smuggling, high economic benefit, in addition to highlight how global vision in front of this type of counterfeits affect European Union member states, joint struggle between the agents involved, customs service and police enforcement, together with European agencies in order to be able to relate the seized good. These organized groups don't operate in a single territory, but the counterfeit goods are stored, shipped, transported, and marketed through different EU countries. Additionally, these criminal organizations are located in different countries inside and outside the European Union. Fake Star is being a great success. We have carried out 2 editions and we are in the process of preparing the 3rd one. You can download a very interesting report of the 1st edition from the EU EPO website. This report describes the results of the operational action. Our idea is to keep making reports in future editions because that put the action into perspective. You can see the results. In conclusion, fighting together is not an easy task due to different legislation, but through the instrument that we normally use, agencies and attachés, it becomes much easier, although sometimes the bureaucracy slows down the process. Thank you for your attention, and I wrote my contact information. Please don't hesitate to contact with me with any question. Thank you so much.
Thank you so much, Maria, for this great presentation. So interesting, I think, to see the effects of this harmonization of practice at the European Union level. And I would like to highlight, even if I didn't say it at the beginning, that I know the big efforts and the excellent work of this intellectual property section of the Policía Nacional. And because of that, if I am not wrong, your section received also prizes and condecoration. And I think it's something important to say, because the work of the Policía Nacional Spanish one is very impressive, and they done a very impressive job at the national and international level. So congratulations for your your commitment with intellectual property, because sometimes you know very well that at the end of the day the national police needs to deal with lots of different topics, as you have seen also from Maria, and sometimes intellectual property is not one of the most well-known, at least in the criminal side. So this is, I think, a very important topic to take into account, and also to be thankful to our police in Spain. I am sure in France they did the same. So I think, I don't know, we are running out of time, so I don't know if we have time for questions. Perhaps if someone of you have one, but only, okay, so I prefer perhaps we keep the question for the break, and I think we will thank you. We will thank our speaker of this roundtable of convergence practice. Thank you so much, and we will pass to the second one. Thank you so much. of practice of the different IP rights. We have seen the different IP rights, the differences we have, or also common practices. We have seen the impressive work of the different offices regarding those IP rights. And now let's go to a hot topic nowadays, artificial intelligence. So we have for this topic impressive and very well-known speaker. Let me introduce you both of them. First of all, we will see the presentation from Carolina Pina. Carolina Pina is head of the Intellectual Property Department, Telecommunication and Media in Garrigues, Madrid. She's a leading expert in dispute resolution and complex IP, digital and artificial intelligence transaction. She has been recognized in the highest category by Chambers Global, Chambers Europe, IP Stars, Top 50 Women Lawyers, and several more. And she has been chosen by the Financial Times as one of the 10 most innovative lawyers in Europe in 2022. I would like to thank Carolina for being here because I know very well the agenda of Carolina. It's not very easy, so to have Carolina here is wonderful for us. She's a former student from the University of Alicante, and she always says that, and I am happy for that. She's also a member of the scientific committee of the Magister Lucentinus, and she will be distinguished this year, particularly for her invaluable support to the Magister since a very long time, because as you know very well, we are in the 30th edition of this Master. After Carolina, we will have the presentation of Stéphanie Lecam. Stéphanie Lecam is Associate Professor at the University of Rennes II, Director of the Authors Leagues. She's responsible for the IP section of Dallos Actualité, and she's member of the Conseil Culturel de Bretagne, co-founder of the CIN2P, National Intellectual Property Litigation Competition. She's also a very well-known speaker in intellectual property and particular artificial intelligence. So with this introduction to the two speakers we have today, I will introduce a little bit the roundtable. So we will deal now with artificial intelligence and intellectual property, and particularly authors' initiatives. If I am not wrong, Carolina Pina will deal first with data mining issues, particularly Article 3 and 4 of the directive, the reforms, and how it's affect to European harmonization. And after, we will hear from Stéphanie Lecam, economic and legal impacts for the creative professions, and particularly the future challenge for the preservation of these professions. So thank you so much to both of you, and Carolina, you have the floor.
Thank you for inviting me and for your nice words. Pilar, you are always so nice to me. But I can never say no to Pilar, so this is even that I did have a number of court hearings this week, so it was a very hectic week, but I'm very, very glad to be here and speaking about this exciting subject of artificial intelligence. I don't know whether, okay. My first message is that we shouldn't be panicked, because if you read Harari, Stephen Hawking, it's like, okay, my God, this is the apocalypse. So probably because I'm getting old and I've been dealing with IP for over 30 years, each time that a new technology arrives, we think that will be the end of authors and the creative industry. I think the law will have a solution, the judges will have a solution. It may take time, and it will be painful. It will be very painful, because this technology is the most revolutionary technology that we'll face. And it is clear that it will remain, but again, with a lot of pain. I'd like to start with this example, and it's when Edison invented the phonograph. Some people consider that this will be the end of the vocal cord and the musician. So fortunately, the society finds always solutions. Before starting talking about the technicalities of Article 3 and 4 of the Digital Single Market Directive, I would like to give you a brief explanation about how the artificial intelligence works, because there are some misunderstandings. And first, what it happens is that there is an ingestion of a very large number of data. Without data, artificial intelligence doesn't work. And the question is where this data is obtained. And most of this data is obtained from public sources, mainly the internet. And in the internet, we can find posts with literary works, we can find news, scientific articles, illustration, pictures, many, many things. So one of the most important sources for the ingestion of the data is the internet, open source. So with this data, a data set is created, and we have now like the magic word, which is the algorithm. So we do have this called neuronal networks, which works with algorithms. And once the prompt, which is the question asked by the user, what we do have is the output delivered by these artificial intelligence services. So what we do have is that the artificial intelligence learn. They do not reproduce, they do not copy, they learn, and with this data that they learn, they provide an output depending on the algorithm and the different methods obtained. It is based on probabilistic results. So, the first question is what happened with the results delivered by the artificial intelligence services? Are they protectable by copyright? The clear answer is no in Europe, no in the States. Only works created by humans, for the time being at least, can be protected by copyright. There are some nuances in other jurisdictions, such as UK and India and Singapore, that they may have another opinions, but for the time being, only works created by humans will be subject to copyright. You can have here the main decisions from the European Court of Justice that conclude this conclusion. And also there is a resolution from the European Parliament from 2020 that states that only works created by human beings are subject to protection by copyright. Since the Americans are so original and they have so fascinating cases, I don't know whether you know the Bonono case. You know this case? So before we did have ChatGPT and all these very exciting services, the Bonono case basically was that this fascinating animal took a selfie, but a photographer was doing the setting. So it was not just the Bonano, the monkey, doing the selfie without being promoted by a human being. So the question was whether the Bonano was the owner of this selfie, which, as you know, it's very cute. He's so cute. I love him. So the conclusion was not. So even if the photographer did the setting and said, the Bonano, you must be nice, probably he do something, I don't know. This is my invention. Don't take it seriously. So basically the conclusion was that it was not protectable. There is another very interesting case from the state, quite recent, from the US Copyright Office that concluded that in this case the illustrations of a comic created by artificial intelligence, in this case it was Midjourney, it was not registrable and therefore it was not subject to copyright. The literary work, which was created by the author, was okay, but the illustrations were carved out, were considered not protectable. So now we'll go into the technicalities of this fascinating subject, which is the data mining. What is the data mining? So as I explained at the beginning, what the artificial intelligence does is they took massive amounts of data from different sources, mainly in the internet. So the first question is, can they do it? What do you think? Can they do it or not? Or is it illegal? Do you think ChatGPT may take thousands and thousands of data that will serve to provide the service. They can go to different media, whatever content. Any opinion? No opinion? Okay, I'll give you the answer. Okay, so the Europeans have been working much earlier than other jurisdictions in finding a solution to this problem, because on one side, I think we can agree that the artificial intelligence may be good for society. Okay. It may also be bad. So this is why it's very important to have, we have to strike the balance and find this equilibrium. So basically, what the Digital Single Market Directive concluded in 2019, earlier than other countries, is that this data mining can be performed by OpenAI and all these companies, by Google, without any limitation if the purpose is the investigation. Okay? So universities and other research organizations can do scrapping, can do crawling to these web pages with no limitation, because of course they assume that there is a public interest, and therefore this public interest will prevail compared to copyright. What happens if it is not only a question of public interest, but there is, they are looking for profit? So private companies, can they do it? So in this case, the European authorities in general concluded that they can do it, so they do not need an authorization to do the web scraping to capture the data that will be used for providing the service, but they say, okay, what you can do is you can do the opt-out, meaning that you can close the door to the spider, to the motor that enters into the web page to access to your content. If you do not open if you do not close the door, they assume that it is completely legal to enter in your web page. So if I am an author and I have plenty of articles about law or about food or whatever, okay, and I do not want my content to be used for artificial intelligence purpose, I do have to close the door of these spiders, the motors that access to my web. How can it be done? It's very easy. It sounds very complicated, but it's very easy. Basically, it's done through what it is called opt-out, which means that you have to include a tag in your open source, in the open code, sorry, saying like, do not enter. It's like if I have a bar, I can say, do not enter spiders, motors, okay? It sounds very complicated, but from a factual point of view, is very straightforward. I think my colleague may have a different opinion, and we will have a further discussion about it. So some media outlets, such as the most important one, probably, which is the New York Times, have already decided to close the door to the artificial intelligence because they do not want to their content to be used by artificial intelligence purposes. So if you're a private company, this is a decision you have to decide. So my following question is, what happens with the outcome, with the result of the artificial intelligence? Is this an infringement of copyright because it may be a replica or it may be a transformation? So this is one of the examples that have been used because, as you can see, there are some similarities. But again, this is not a reproduction or a transformation. This is just the artificial intelligence learning from thousands and thousands of pictures that most of them include the Getty Images watermark, and the outcome was the other one. So there may be similarities. So the question is whether this is a derivative work or this is a new work and there is infringement. I don't know whether you have any opinion about it because this is I mean, there is legal uncertainty at least. You can think about it while I'm providing this boring explanation. So another decision that may seem irrelevant for the artificial intelligence is the Andy Warhol Supreme Court decision in the States, because basically it is providing a very restrictive interpretation of what is transformative use, and this may have a very negative impact in the States regarding the evolution of artificial intelligence. Some artificial intelligence services, what they are doing is they are also providing filters. For example, if your children, or you are very young, you don't have children, sorry, but if you have some curiosity and you say, okay, I want a Mickey Mouse dressed like Fallera, which is like the Valencia festival, so probably the Mickey Mouse will not be delivered because OpenAI, for example, has already implementing filters, not with all the characters, but as you know, Mickey Mouse is the one. Okay, so very briefly to explain how the AI impact is having in the real life, because we are talking about AI. Sometimes we cannot see like the real effect. Probably you are aware of the strikes in the States, in the Hollywood industry. First it were the scriptwriters, and also the actors. They are on a strike. Fortunately, they are resolving everything because of the AI, because they think the AI may replace actors, may replace their voice, and also it has already been proved that they do very good scripters. So basically, there is an agreement between the majors, the largest American production companies, and the writers to find a balance between how the artificial intelligence can be used. They cannot be forced to use it, and the actors cannot be replaced by artificial intelligence, because the problem is that in the agreements they were already requesting the assignment of the rights for artificial intelligence purposes. So another recommendation is, I know it's very boring and I always send this message, but you have to read the terms and conditions of these companies. In particular because I was very surprised to see that the companies assign the intellectual property rights to the users. So it's very strange when an American company assigns the IP rights. Basically, it's because, as I said at the beginning, they are not protectable. But just in case, if there is something which probably not, they will be yours. And I have to read this because it's fascinating. There is also a limitation of liability, very straightforward, very tough. They say, if you knowingly infringe someone else's intellectual property and that costs us money, we are going to come find you and collect the money from you. We might also do other stuff. We don't know what is going to be the other stuff. Don't ask. Like try to get a court to make you pay our money, attorney fees. Don't do it. So recommendation, if you read these terms and conditions, what they say, okay, do not use content that may be protected by copyright, because they will not assume, as usual, any liability. They do it as is. It is your problem. So if there is an output, do not assume that the output delivered by the artificial intelligence is clean. It may not be clean, and you will be fully liable. And as you know, you cannot claim anything to the platform. So just to give you a brief explanation about where we are, the Spanish government is putting, no sé cómo se dice ahora en funciones, the Spanish government is putting a lot of pressure to have the artificial intelligence European regulation adopted by the end of the year. Currently is under the trilogues, which means that the Commission, the Parliament, and the three bodies of the European organizations are trying to reach an agreement. There is huge controversy, in particular regarding foundation models, what it's like ChatGPT, and also regarding copyright. Copyright is getting a big issue because some stakeholders maintain that copyright should be completely excluded from the artificial intelligence regulation. They say that everything is already under a lot of regulations, so we do not need another layer, because the main problem is what we call the interplay. So we have one lawyer, another lawyer. So if you are a lawyer, you are completely lost because you don't know which laws apply. So it is creating a very convoluted, a very complex system, difficult to manage, and it creates a lot of legal uncertainty. So if I do have to launch a business, the clearance of the business is getting very, very difficult. And we need legal certainty. We need to compete with the Americans. And for such purposes, we need to have clear rules. And for the time being, I have read the proposal of the artificial intelligence regulation, and I cannot provide you any guarantee regarding the outcome, because it's so difficult, and there is not they are still discussing about the definition. I think this is extremely convoluted. The last proposal includes just a very brief specification on copyright, and basically what it says is that these services must publish summaries of the training data protected by IP with which they have been fed. So they want to understand what is the source of the data, but the source of the data doesn't mean that the outcome may be infringing, but they need to be transparent about where these companies obtain the data. But this is very controversial, and we do not know what will be the final outcome. And this is my brief explanation of this complex matter. Thank you.
Thank you so much, Carolina. It has been impressive, your presentation, as always. And I must say that we are not afraid. I am even happy, because this shows that the market needs experts on IP and digital innovation. So there is lots of work for our students here and in Lille. So I hope we will have your guidance also in other lectures in this year, in order to know how to move between the different laws in this field. Thank you so much, Carolina.
Anytime.
And now we will move to Stephanie. I don't know if you prefer to move or you stay here. Okay. So you have the floor. Merci.
Thank you. Thank you, Caroline and Pilar, for the invitation. I'm so happy to be here with you. Congratulations for this wonderful organization. You take me out of my comfort zone by asking me to speak English, but I do it with pleasure for my two dear friends. So thank you very much. Donc, I would like to talk about the consequences for creators. And I'm so sorry, but I am a member of the team of people who think it's an apocalypse. So maybe it's because I represent a professional organization which defend precarious artists, creators, who are really not quiet. So AI will fundamentally change the world of work even more radically than the first industrial revolution. In fact, the question is, what impacts can we see, and what could they be in the months and the years to come? And to answer this question, we must ask another one. Are creative professions automatable professions? Because it is the level of automation of the profession which will determine the impact of AI. A recent study on the employment consequences of ChatGPT demonstrates that 80% of professions will see 10% of their tasks transformed by AI. And for 19% of profession, the number of impact tasks rise to 50%. And creative professions are in this second part of the study. It concerns poet, interpret, translator, writer, journalist. And it's just for ChatGPT, so we can also add a music composer, a video game creator, graphic artist, etc., etc. The first impact, it is the loss of activities and remuneration. For example, book covers represent an income between 500 to 1,000 euros. A service like Midjourney offers a radically different alternative. The subscription is around 20 euros for a month. And you can generate thousands of potential illustrations for a book cover. It concerns article, it concerns illustration for magazine, poster for cinema, etc., etc. These activities are essential for creators, and they need these secondary activities to live and to make books, because contracts are too poorly paid. So the risk is a deprofessionalization of creators who are too precarious. In China, for example, some video game companies laid off half of their designers. Secondly, another consequence, overproduction and eviction. Because producing text or illustration with artificial intelligence is quick and easy. We can send tons and tons of text and illustration to operators. It's like a form of spam. Classword stopped processing text coming from outside, and it continues to work just with the same creators, and prefers to stop any new collaboration. So imagine the problem for young creators. This kind of eviction and overproduction is really a problem for the new generation of creators. And there is the question of parasitism and unfair competition. On the website Night Cafe, we can see that the name of Greg Rutowski was used to create 4 million illustrations. The consequence is a distortion of competition, as in the sector of the fashion. Fast fashion has generated massive outsourcing to achieve more productivity. We have seen the social and ecological devastation caused by the T-shirt, which cost only 5 euros. And it is simple to compare. Artificial intelligence is going to reduce the psychological price of the creation, and maybe the value of the intellectual property. Who will pay 1,000 euros for a book cover in 2 years? Probably no one anymore. Obviously, AI raised questions about the intellectual property right. Academic doctrine seems divided. Is the massive ingestion or aspiration of works to training robots constitutes an attack of the intellectual property? Honestly, I don't know. Some days I am sure, because learning implies memorization. And other day, I adopt it completely because I speak with scientists who tell me that it is such tiny bits of the work that are used, and we cannot speak about a form of reproduction. So maybe solutions are beyond. In France, we have the theory of unjust enrichment, enrichissement sans cause. Talking about it in French is really difficult, so I don't try to do it in English. But the value of the new tech companies is correlated to the massive ingestion aspiration. We could say plunder of the work of the creators. So, what solution? Maybe we can have a reflection about opt-out. Opt-out is the safeguard. Okay. I think this opt-out is only an illusion. It doesn't work. The opt-out is not a safeguard because we tried with this cover. This cover, c'est Les Super. Les Super, Frédéric Maupaumé and David Skomik. With the site Have I Been Trained? We get 40 illustrations in the database just to look after Les Super. Okay? These illustrations were taken from bookseller sites, comic book review blogs, etc., etc., and came from everywhere. Maupaumé, the creator, opted out on his site, and his publisher did the same, but their efforts were destroyed by the negligence of the other people. And there are 40 illustrations for one book. But Frédéric Maupaumé was written more than 30 books. He needs a lot of time to have to control the using of his illustration. Will Stable Diffusion agree to retrain its robots after releasing the illustration? I don't know. The opt-out does not work. And the recommendation need to change. Regulation, we need to think about technical solutions to regulate tech companies. There are techniques for associating illustration with a virus, like a poison, to perturb the algorithm. Let's us them. Other solution, public institutions have to defend professionals. They must call on humans and not massively use AI to generate their communication. Imposition, because all the specific measures put in place for human work, for example, tax, TVA, VAT, yes, tax, reduced for book, I think cannot benefit synthetic production generated by AI. A Midjourney or ChatGPT book must be it must be a full rate tax. Formation, we need to integrate AI into the program school to ensure it is used ethically. If tomorrow we delegate everything to it, I fear that the collective thinking will be change, different. And compensation, because the expansion of digital platforms, the high concentration of oligopolies and the overproduction of works in the market have led to fierce and violent competition for creators. The COVID crisis has made this situation worse, and the cataclysm caused by artificial intelligence is not helping matters. Creators have lost important remuneration and will soon lose activities. And without intervention, creative profession will soon be reserved for a very privileged social professional circles to the detriment of cultural diversity. So, muchas gracias.
Thank you, Stephanie, particularly for your energy in this presentation, and thank you both of you, because I think it's so important to have both sides in the same round table to have this.
But just to be clear, I also support creators and technology.
I know very well. But perhaps even if we don't have so much time for questions, I don't know if perhaps you could say something regarding the opt-out, because I don't know, when Stephanie spoke about that, I feel you weren't so.
No, I think she said, I fully agree with her. She said that the solution is the technology, and probably the opt-out may have some pitfalls that has to be resolved. But for the time being, this is the most appropriate solution because it's the way to find this balance. But I'm sure they will still develop other tools. But my information is that it works in a large percentage. Of course, there will always be ways to circumvent, because we know that from history, not the 20th century, but from history, there have always been copies. But it's true that we have to support creators, and the law must find this right balance between technology and creators, which is very difficult, and it's going to be very painful. I fully agree that precarity, I don't know if it's precarity, but it will have a huge impact. So I don't know whether we have any questions.
Thank you so much. I don't know if you have any questions. Only one, because we have no time for the other round table. Yes, no? Okay, so thank you again, Carolina and Stephanie. It has been a privilege for me to be chairing this exceptional panel. And now we will move. We were dealing with authors, with artificial intelligence, but all those intellectual property rights are owned by companies. So we will close this seminar with a business roundtable chaired by Nuria Fernandez, Professor Nuria Fernandez. Thank you so much.
last but not least, we have now the final round table. This table is about the interplay between corporate law and intellectual property and sustainability too. Corporate, there are many interesting questions that can be analyzed, such as trademark and corporate name, and, for example, new due diligence directive on ESG. These questions will be analyzed by, I know, 3 brilliant speakers. It's a pleasure to introduce them to you. Simon,
that's perfect.
Right. He's associate professor of University of Lille and lawyer. And Ascensión Gallego, a professor of commercial law for University of Castilla-La Mancha, and Jorge Moya, professor of commercial law of University of Alicante. Ascensión and Jorge, both of them are specialists in company law. They are authors of many publications in this field and habitual speakers on national and international conferences. First, Ascensión and Simon will speak about conflict or relationship, between trademark and corporate name, both on Spain and France. The floor is yours.
Thank you very much. So, hello everyone, dear colleagues, dear students. Firstly, I want to thank you for having me here in the lovely city of Alicante, especially in this beautiful university. For the record, I discovered this city when I was younger, and this is now an absolute pleasure to come back. Moreover, in November, to enjoy this very, very good weather, so different from mine in the north of the France, of my country. I'm also very glad to be surrounded by such amazing legal professionals and scholars to talk, among other things, about business law and IP in order to compare our two legal systems. I also would like to take this opportunity to express my full gratitude to the organizers for their efforts in bringing us together for open discussions. For my part, I'm going to focus my study on the French rules regarding the use of corporate names, and I will try to be short because I presume that you are many in this room to be hungry like me.
Including me.
Only the French one, yeah.
Even in this board.
It's not the same time for the lunch in our countries. Well, to begin, as I learned it when I was a student myself, and I'm seeing some students here, I would like to introduce the concept of corporate name with few definitions, just to make sure of word meanings. Like a natural person has a name to be recognized, a legal entity must have a corporate name to be identified, particularly in relation to its competitors, to avoid confusion in the minds of third parties. For the record, the corporate name is compulsory for commercial companies, optional for civil companies, and excluded for unincorporated companies. The corporate name must be lawful, distinctive, and available. These three rules, these three requirements, can be analyzed in turn. Firstly, the corporate name must not violate public policy or morality. For instance, a French private sector company may use the adjective national in its corporate name, but it is forbidden to suggest that the company belongs to the public sector. So in our French law, there are some nuances to keep in mind. Furthermore, the company name must distinguish the company and separate it from others. So to follow this idea, the name should not be generic. For instance, the name could not include a term that any of the competitors could use, such as Society for the Protection of Animals. Finally, the corporate name must be available, which means that the sign must not create some confusion in the mind of third parties, like I said. For this reason, the corporate name should not be the trade name of a company belonging to the same sector of activity. Moreover, the corporate name must not be confused with other similar but not identical concepts. First of all, a trade name is a name given to a business to recognize it, linked to the company activity and not to the legal entity. The right to a trade name arises from use. In addition, a sign is any inscription, shape, or image attached to a building and relating to an activity carried on there. Indeed, the sign locates the business in the eye of customers. If you are looking for a catchphrase here, it's possible to remember that the right to a sign arises from use. It disappears if it's not used. That's what you have to understand here, to my mind. Finally, the last one, a trademark, is not a corporate name. More precisely, a trademark could be defined as, I quote, a sign capable of graphic representation used to distinguish the proceeds or services of a natural person. Now, for my second part, I think it's time to speak about some rules governing the choice of corporate name. But before to begin this study, it should be noticed that it's a quite old legal construction. Indeed, the rules governing the choice of a company name, trade name, or trademarks are not the result of a new law, but of different case law over the years. With this in mind, first of all, the corporate name is often taken from the company's activity. However, it must not be descriptive, like the Great Tannery. To respect this rule, it's possible to combine different words, like the Great Tannery from Alicante. Secondly, the corporate name may include the name of one or more shareholders, the watchmaking Jaeger-LeCoultre, for instance. In the famous Bordas case law in 1985, the Cour de Cassation, our Supreme Court in France in private law, ruled that the principle of the inalienability and imprescriptibility, it was the hard part of my speech, inalienability and imprescriptibility, it's very hard to pronounce, of a name does not exclude the use of this name as a corporate name. On this topic, the Paris Court of Appeal has clearly specified that the use of a founder family name could be the result of a tacit agreement. It's very important to keep in mind, too, that this rule also applies to trade names. Thirdly, the Bordas case law applies to trademarks. According to the case law, a company can continue to use the Inès de la Fressange brand trademarks after her departure from this company. This solution should be approved on the basis of the Article 1628 of the French Code Civil, since Inès de la Fressange had sold the rights to trademarks that included her identity. Therefore, this is the same rule, the theory of detachment, to be precise, which applied to corporate names, trade names, and trademarks. If this rule is not the same everywhere in Europe, we can be at least satisfied with the consistency of various French case law on this point. However, there are at least one limit to this theory that should be considered. Indeed, the right to use the founding shareholder's surname as a corporate name or trade name does not authorize the company to use it as a trademark. So this rule limits the scope of the Bordas case law, because for a company it's impossible to use the corporate name as a trademark. If the company wishes to do it, a specific agreement has to be signed before. To conclude, I would like to thank once again the organizers of this beautiful symposium. Thank you very, very much for listening. Muchas gracias, like you said.
Thank you, very interesting. I have learned a lot about French system. Please, Concepción, floor is yours.
Okay. Well, thank you very much, Nuria, and of course it's a pleasure for me to be here participating in this seminar and also in this roundtable. So thank you, Pilar, for having invited me to be here. And well, I'm going to talk about this topic also, the conflicts between trademarks and company names from the point of view of the Spanish regulation. And well, I have some definitions there, but Simon has already talked about this, so I will now the problem because we don't have time, so it's okay. So I will go directly through to the second point, which is, well, there is here I'm going to talk about the conflict between company name and trademarks, and the idea is when the use of a company name can be an infringement of a trademark, but I'd like to go through a prior topic, which is what are the preventive mechanisms set forth in the regulation to prevent the conflict. These preventive mechanisms have some limitations, and in the context of this limitation is where we have the conflict. And I think that the regulation in France is not exactly the same in some points. Well, the preventive mechanism when we are creating a company, that is to say when we are applying for a given name for a company we want to create, or when the company is going to be registered in the registry office, we have the important provision there, this additional provision 14 of the trademark regulation, that is in the trademark regulation, not in the Companies Act or whatever. It states that the registry bodies have to deny a company name that coincides or where there is a likelihood of confusion with a trademark, but not any trademark, just trademarks with reputation in the terms of the Trademark Act. Well, this control is applied by the registry bodies. It is an ex officio controlled. It is more limited than the control that the trademark office can perform, and it applies where the trademark is very, very famous, and where there is a very clear case, and where there is a clear identity between the signs and the company name. I mean, it's not. It's a very more limited control as the control that the trademark office can perform, and it is applied only when it is very clear. So as in the examples you have there, so it can be applied. But the idea is that if the trademark is not so famous, is not so well known, it has no reputation, then the company can be registered with this name, which can be confused with the trademark. So here we can have the conflict. When
both operate in the same sector in the course of trade. If we move to the other side, that is when we are registering a trademark, we have, in the context of the relative grounds for refusal of a trademark, we have the Article 9 of the Spanish Trademark Act, which states that the company name can be a ground for refusal of a trademark when there is a likelihood of confusion among the public, which is something that I think that's the same as that appear in the French regulation. But what we have, and you don't have, I think, unless I'm wrong, is that it only applies when the holder of the sign, I mean, when the company can provide evidence of the use throughout the Spanish territory, the whole the Spanish territory, or well-known knowledge of the company name in the territory, or at least a significant part of the Spanish territory. But not if the company name is known locally. That is what happened in the case you have there. There the judge said, well, the name and the sign and the trademark, it's very similar. There is a high risk of confusion here, but the company operates in a specific part of the Spanish territory. It is the knowledge of the public is very reduced, so it cannot be an impediment for the registration of the trademark. So, I mean, you cannot avoid this. So we have the company with this name, and then we have also the trademark registered with a similar name. So we have the conflict, and I think you don't have this limitation. So I think that you prevent a conflict better than we prevent such conflict. Well, if that's the case, so a trademark can be an impediment for the registration of a company with a given name only if the trademark is very famous, well-known, and with reputation. The company name can prevent the registration of a trademark only when the company name is well-known in the Spanish territory. Then we have this conflict, this possible use in the course of trade when they operate in the same sector, the company with the name, and then we have also the trademark. And here we have the conflict. And the point is, when the use of the trademark, the company name, can be considered to be an infringement of a trademark. Here we have, well, the elements in the Spanish regulation to solve the conflict, which are the elements that come from the trademark directive transposed, implemented in 2018 in Spain. We have, on the one hand, Article 34, which is the 10th of the directive, that says that the holder of a trademark can prohibit the use of a trademark as part of a company name or as a company name, and also in business paper and advertising. And also we have, in the context of the limitation of the effects of a trademark, that the holder of a trademark cannot prohibit that a third party uses the name in the context of honest practices. But now it has been made explicit that it only applies when we have natural persons. So, well, in the situation prior to the reform, what we had is this limitation applied to, it was just the name of third party. And, well, in accordance to the European Court of Justice assessment, as there was, we don't have any specification, so this limitation, this own name defense, applied both to natural persons and also to companies. So we could justify the use of the name of the company in the course of trade if it was in the context of honest practices. But this does not apply anymore for companies. Well, the most famous case with regard to this was the selling case by the European Court of Justice, and what the selling case said was, well, this, the company name can also rely on this limitation. And also there is a statement of the selling case that has given rise to some discussions in the Spanish literature. which is the one you have there. The European Court of Justice pointed out that, well, the purpose of the name of the company is to identify the company as a legal entity with duties, responsibilities, obligations, to identify the corporation, that is the legal sphere. And it said where the use of a company name is limited to, that's, for me it's important, limited to identifying a company, then it cannot be considered a use in relation to goods and services. It is one of the requirements for the trademark infringement. And, well, based on this case law, what the Spanish courts started to do was to distinguish, taking into consideration the use of the company name that was made in order to assess if it was or not a trademark infringement. So the criteria are there. The Spanish courts consider, well, if it is used in the strictly legal sphere, no problem, because it is required a use in the course of trade, so this cannot be trademark infringement. Then the second group of cases where we are using the company name as a trademark. In the past, I mean, the situation prior to the reform, this was an infringement of a trademark. This use was not covered by the own name defense, and of course we don't have the own name defense anymore, so it is also an infringement of a trademark. But what I want to point out is that in some cases it is not a problem, it's not a conflict between the company name and the trademark, because it is just a conflict between the trademark and a sign that are a couple of words that are part of the company name. So bear in mind that the company name is, for example, in these examples, is the whole thing. The whole thing, together with the reference to the type of the company. That's the rules governing the name of the company, make it clear that the company name is the whole thing, together with SL, SA, I mean, the type of the company. So in these cases, the conflict was not between the company name and a trademark. It was a conflict between some words that were part of the company name and then a trademark. So it's a clear case of here is not really a conflict between the company name. The company was making use of some words, part of the company name, but not the company name. And here we have the obviously conflict, and it is not covered. It was not covered by the own name defense. Now we don't have this, but it is a clear case of trademark infringement. In these cases, well, in some of these cases, what the Spanish courts did was to, for example, the first one, to order the company to change the name as a consequence of the infringement. So the judge said, you have to change your name because there is a conflict with a trademark already registered. In the second one, it was not the case. In the second one, maybe because the plaintiff didn't ask for that, but the judge said, you can use the name to identify as a company, to identify as a corporation with a legal entity, with duties and so on, and you cannot use to identify the source of the product, that is the distinctive sign. But the idea is that in some cases it is difficult to separate this. Maybe they are separated because, for example, we have the company names that is used together with a trademark. I mean, the company is identifying as a legal entity, and then we have the products sold by the company with a different trademark. But in these cases, I mean, the company is an economic operator. It's engaged in a business activity. So even if we are identifying the company, a message is sent also to the market. This company identified with this name is the producer of this product. So here we have the link. Here we have also the problem. Because it is not so easy to separate these functions, to separate this information that is sent to the market. In the past, we had the own name defense. So this was a case, this group of cases could rely on the own name defense. Maybe there is this risk of confusion because we are sending messages to the market, but I am identifying, the main purpose is to identify myself as a company producing as an economic operator, and I rely, my use is covered by the own name defense. But now we don't have the own name defense. Well, the own name defense could be applied depending on the circumstances. I mean, not every use of the company name to identify the company together with different trademarks was covered by the own name defense. For example, in the case you have there, the company name was one. The company was making use of the company name together with the SLA reference. The company was using a trademark different from the company name to identify, to distinguish the products, but the word that was in conflict with the trademark was prominent. So, well, it was not covered by the own name defense. So it was something like, more or less like this, I guess. So it was not covered by this honest practices exception. But it would maybe be covered if the use was like this, not prominent, together with a different trademark. Even in these cases, in some of the resolutions, it was considered that this was not, the last one, was not covered by the honest practice defense, own name defense, because, well, there are some resolutions that in the context of conflicts between members of the same family, I mean, they were together engaged in an economic activity, then there are discussions, then part of the company separate, they create a new company, the name of the new company is similar to the name of the previous company, and the name is also takes the surname of the company, which is also the trademark. So it is in the context of a conflict between members of the family, and it was considered not to be honest and fair. So, but anyway, we don't have it anymore. I mean, even if these cases, it was not covered by the own name defense, but obviously now we don't have the own name defense. So what happens now that we don't have this own name defense when we are talking about companies, not if we are talking about natural persons? And for me, the example, the most clear example is this, and when the company uses the name to identify the company as the producer of a product. So the company cannot avoid, because there is regulation that obliges the company to identify itself as being the producer of the product. So even if the company is using this together with a different trademark, the message is sent to the market. I'm a company, but also I'm the producer of this product. And this example has given rise to some discussions in the Spanish literature as a consequence of not the elimination of the own name defense for companies. Well, there are some authors that consider that even in this case, and even if we don't have anymore the own name defense, this use cannot be an infringement of a trademark, because this use cannot be a use in relation to goods or services. They say, well, the selling case, the European Court of Justice said in the selling case, if the purpose of the company name is to identify the company, if the use is to identify the company, then it is not a use in relation to goods and services. So for some authors in the Spanish literature, no way can this be an infringement of a trademark, even now that we don't have the prior name, the own name defense. Also provided all the rest of circumstances are met, risk of association, risk of confusion, and so on. Yeah. For other sector, and I think that's the point of the reform, now we can have this kind of use can be an infringement of a trademark, and that is maybe the point of the reform. What the European Court of Justice said in the selling case was not exactly that when the use of the company is to identify, when the use of the company name is to identify the company, then we don't have a use in relation to goods and services. What the European Court of Justice said in the selling case was when the use is limited to identify the company, then it is not a use in relation to goods and services. But in the case I'm telling you, the use is not limited to identify the company, because there is another message, maybe unavoidably, but this is another message that is sent to the market. And what the European Court of Justice said in the selling case was, if a link can be established between the company with a given name and the products that the company is selling, then we have a use in relation to goods and services. So now that we don't have the own name defense for companies, it might be, provided all the conditions are met, it might be an infringement of a trademark. And that is what even the proposal for a trademark directive stated. Here you have this sentence, the first one, according to the Court of Justice, the Article 5 of Directive is applicable where the public considers the use of a company name as also relating to goods and services. This is not only to identify the company, but also to send this information as to the source of the product. And while there are some discussions here, it's not very clear, but it might also apply even in the cases where the company was created before the registration of the company. Because the Spanish courts used to consider that if the company was created before, then the use of the company name to identify the company was in good faith, so it was covered by the honest practice, the own name defense. But now we don't have this, the own name defense. And if the company was created before, but the company name is not so well known to impede the registration of the company, then we have this conflict. And the trademark infringement, I mean, what the Article 34 says is, without prejudice to prior rights, the holder of the trademark can prohibit the use of the sign, But the prior rights, what are prior rights? If prior rights are the rights that can impede the registration of a trademark, then if the company was created before, but it is not so well known, then it is not a prior right. And then we can have an infringement of a trademark. So I think that's the consequence of the reform, that now the own name defense only applies to natural persons, but not to companies. And well, that's all I think I'm a little...
Thank you very much. As Simon, it's a great, excellent presentation. And now Professor Moya is going to talk about new due diligence in directive on ESG. And Professor Moya, the floor is yours.
Thank you very much. First of all, I would like to thank the organizers of this meeting for inviting me to participate in this board. I also want to thank for being the last one. I always love to be the last one, because nobody really cares about the last one. This is my privilege. No, being serious, it's a real pleasure to be here in my university, sharing the board with my colleagues. I'm very, very happy. I'm going to talk about the new Corporate Sustainability Due Diligence Directive proposal. This directive, this proposal, is aimed to deal with the ESG criteria in the corporate field, the relation with the companies. ESG stands for Environmental, Corporate Social Responsibility, and Corporate Governance. Corporate governance aims to eradicate any kind of abuse from the directors to shareholders, especially the minority of the shareholders, while corporate social responsibility makes it possible to take in account the interests of other people different than the shareholders, like the so-called stakeholders, which are linked to the social rights, human rights of these stakeholders. And finally, the environmental aims to, this part deals with the threat of the climate change and obliges the directors to take in account environmental policies in the field of business as well. The protection of the ESG criteria originally emerged as a series of self-imposed rules that allow or oblige directors to publish the achievements, the progress that the companies made in this field. This self-regulating field perspective have changed into a non-self-regulating from soft law perspective to a hard law perspective. And we can highlight a couple of laws. The first one is Spanish law. I'm pointing out this law because we are in Spain now, and because I'm a Spanish professor, of course. It's the Spanish law 11/2019 that deals with non-financial information. And the point of my talk is going to be the European Corporate Sustainability Due Diligence Directive proposal from the Commission that is launched in 2021 and right now is contested by the Council, and there's certain amendments also by the Parliament. So we are now in the process of getting a negotiation between the three institutions in order to see the final come out of these regulations. Let me start by analyzing the scope of application of this proposal, of this bill. It is meant to be obligatory for companies with a minimum of 500 employees and also a turnover of 150 million euros. The Commission estimates that this regulation is going to be mandatory for a little bit less than 10,000 companies in whole Europe. I was doing some research this week, and according to Informa, which is a database dealing with economic aspects of companies in Spain, only in Spain it will be mandatory for more than 1,500 companies, which is not very little. I mean, this is not thought, or it was not meant for the listed companies of the IBEX 35 or the CAC 40. No, it's going to affect a lot more companies. It's going to affect medium companies and also large companies. Not the small companies, but medium companies are going to affect. Spain is not a country known because of the amount of big companies, and even though we have 1,500 companies affected by the regulations. So it's not that little, the scope of appliance. In order to talk about the structure of the company, we can point out three different pillars or areas in which the directive is composed. In this regard, we can talk about the specific obligations, we can talk about the enforcement, secondly, of these specific obligations, and thirdly, the effect that these obligations has over the directors, especially over the fiduciary duties, especially the duty of care. To begin with the specific obligations, we can point out 5-6 obligations. The first one is the duty to implement and also publish a due diligence of policy over sustainability, a duty to identify the risk for human rights and environmental impacts, the duty the company have to mitigate or deal with this risk that has been detected before, and also the duty to analyze, to evaluate yearly, how this company is fulfilling with the obligations, and especially regarding to this risk that has been detected before. On the other hand, the company also has the duty to establish a complaint procedure in order that anyone, any particular, can file a claim against the company for failing to fulfill the obligations. There are two different paths in order to enforce the previous obligations. The first one is the administrative supervision. In this way, the member states should appoint a national authority in order to supervise the fulfillment of the obligations by the companies affected by the regulations. In this regard, this national authority even can can impose fines on the companies that don't fulfill the obligations. And the second path is the civil liability. The infringement of these obligations obviously can produce damages in people, in particulars. So these damages can be, these particulars can claim for remedies for the damage they suffer through the infringement of the previous obligations. Thirdly, and probably the most important part, I just want to point it out because it will take a lot of time to talk about the directive of care, the duty of care. But I believe what it says in Article 25 is important. Well, we have certain obligations that can modify the way directors perform their activity, their duties. So this can affect the performance of the fiducial duties, especially Article 25 of the proposal deals with the duty of care. Let me read. It says, when fulfilling their duty to act in the best interest of the company, directors of the company referred in Article 2, the one we talked before with the scope, should take in account the consequences of their decisions for sustainability matters, including, where applicable, human rights, climate change, environmental consequences, including the short, medium, and long term. Some have said that these regulations, in reality, doesn't affect the duty of care, that they really affect the duty of loyalty and also the corporate interest, since directors have to take in account the stakeholders' interest together with the shareholders' interest. Before, from a contractual point of view, we say that normally directors have to take in account only or mainly the interest of the shareholders. Well, some people say that this Article 25 allows or obliges directors to take in account not only this interest of the shareholders, but also the interest of the stakeholders. However, I believe this is not the aim of the Commission. I believe there is another explanation. If we consider the content of the duty of care, such as the duty of legal compliance, the duty to stay informed, to monitor, to investigate, in the different fields that affect the company, the production or the financial situation, the accounting, the labor aspect, or any other legal, the directive, if we think about this content, I believe what the bill tries to do is to create another section where the directors can allocate funds or assets in order to be informed, to have a legal compliance, in order to monitor or to investigate the fields of, the part of their performance that deals with sustainability. Therefore, I believe what the directive tries to do is to say, if you allocate funds in this, you're not in a breach of the fiduciary duties. You're doing right, because this is not corporate waste. This is important for the company. And it's important because I say it, because the directive say it is important. It's in the best interest of the company, of the shareholders, in the long term, but it's in the best interest of the shareholders. Thank you very much.
Thank you, Jorge. It's an interesting and suggestive topic.
Thank you.
Presentation. Now, any question in the audience? No? Congratulations, and
thank you.
I think, no? Sí. Please, Caroline, Edith, and Pilar, come here. Thank you.
So we are at the end of our seminar, and even if we are 4 in this table, we are only here to thank everyone. And as we have developed this seminar in collaboration with the University of Lille, we would like to have some words from the different director of this seminar. So if Nuria agrees, we can start with Edith after Nuria. It's okay for you? So Edith, please, you have the floor, s'il vous plaît.
Merci. Simply, I would like pardon. Donc, je crois que je vais le faire en français, ce sera plus simple. Je voulais simplement remercier donc tous les intervenants pour la qualité de leurs interventions, de leurs contributions, et aussi bien sûr remercier l'ensemble des participants. Donc, bien évidemment, nos amis espagnols, les étudiants espagnols, le public français qui nous voit en visio, et j'espère que nous nous reverrons bientôt donc pour une nouvelle conférence, soit sur la propriété intellectuelle, soit sur un autre sujet, parce que je crois qu'on a compris que le sujet était inépuisable et qu'on pouvait le décliner dans toutes les matières, notamment en droit des affaires. Donc une nouvelle conférence à Lille peut-être. Merci.
Merci Caroline, Edith. Ça a été un plaisir d'avoir partagé ces 2 jours avec nos collègues français, avec notre étudiant français en español. Y como ya he hablado en francés, yo lo voy a hacer porque estamos en esto es multilingüe, ¿verdad? Bueno, pues muchísimas gracias, que estamos convencidas que esto ha sido muy provechoso y que queremos también repetirlo pronto, así que hope you see you for the edition. Thank you.
Muchas gracias, Nuria, y Pilar también. Mil gracias por todo. Ha sido un placer y un honor estar aquí. I really want to thank everyone, all the speakers, for fascinating presentations. I learned a lot. And the students from Magister Lucentinus, and also a special petit coucou to our students in Lille. Next time you'll be here physically with us in January, so prepare your bathing suits and T-shirts. We look forward to that. So thank you so much.
So thank you so much. I don't know if we will need T-shirts in January, because even in January, sometimes in Alicante, it's a little bit, it's freezing, at least for us, perhaps not for you. Nevertheless, I would like to thank again our speakers. Also, really a big thanks to the organizers, and in this regard, I need to highlight, first of all, the big help from the University of Lille regarding the program, regarding the French speakers. You have really done a very nice work, Edith, Caroline, and Anaïs also. So thank you so much for that. And regarding our team, I would like to thank all the different members of our commercial law department of the Magister Lucentinus. It's a very big work, and sometimes it's not, when things come more or less in a very nice way, we think it's something very easy, but I can assure it's not. And behind this seminar, there are lots of participants, lots of people from our department, so a big thanks to all of them. First of all, perhaps to the speakers. I can see here Professor Pilar Iñiguez, Professor Altea Sensi, Vicente Jimeno, Ignacio Rabasa, Jorge Moya. Thank you so much. Thank you to Ascension, but thank you very much to Jaume Llorca, Miguel Cano, and Álvaro Asencio. You have been there for the different issues we need to solve at the last minute, so thank you so much for everything. Thank you to all the speakers, thank you to the students, and we finish today, Friday afternoon, so now you are free until next Monday. Thank you so much.